Your Honor, at this time, Mr. Harrison's going to withdraw his previously entered plea of not guilty and enter a plea of no contest to count 2. Counts 1 and 3 will be null prost. There will be a withhold of adjudication on count 2, 3 years probation, cost of supervision waived, 515 fines and court costs, and an anger management course.
All right, Mr. Harrison, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
You swear to tell the truth?
Yes, sir.
Okay. This is State of Florida versus Byron Harrison, 24 CF 1454. You want to enter a no contest plea to the charge of resisting with violence, a third-degree felony, and the other 2 counts will be dismissed, correct?
Yes, sir.
Your Honor.
Did you read and sign this score sheet? Did you read and sign this?
Yes, sir.
It explains your rights you're
Yes, sir.
waiving. Are you aware of the rights you are waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Hardy's done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 2, resisting with violence, sentences you to 3 years probation, cost of supervision waived, $515 fine and court costs. Take an anger management course, and adjudication is withheld. Okay? Thank you.
Thank you, Your Honor.
Randy Merrifield. Morning.
First one I have is Blada.
Chad Blada.
And Judge Brandy Merrifield on behalf of Chad Blada in 22 CF 941. It is a violation of probation. Judge, if we could recall him a little bit later on this morning, I am working on something that may lead to resolution.
All right, thank you.
Thank you, Judge. And the next case I have is Mr. Packard. Brandy Merrifield on behalf of Matthew Packard. It's 24 CF 1455 and 1456. We're here today, Judge, on our motion to reinstate bond. Mr. Packard was originally arrested for 2 counts of failure to register in June of this year. 1 count dealt with not updating an email address. The 2nd count dealt with employment, not reporting employment. Mr. Packard was actually helping out a family friend just a few days with painting. His original conviction comes from 1997, and he has been on the registry since. In August, he was arrested for a new misdemeanor related to violation of an injunction. It was a tiff with a neighbor. In September, he did resolve that in misdemeanor court. He didn't violate any other pretrial conditions that we're aware of while he was on supervision. He was compliant. He does live locally in Crestview with most of his family. His mother suffered a debilitating injury when she was younger. Unfortunately, it's become exacerbated with age. He does function as a caretaker for her and would continue to do so if his bond was reinstated. And we're asking the court to reinstate that original bond. It would have been $2,500 each count for a total of $5,000 with a GPS monitor to ensure safety to the community.
Your Honor, the state is opposing the reinstatement despite the fact that he did have a prior failure to register. He was granted a reasonable bond, and while out on bond, he did commit the new law violation, as Ms. Merrifield stated, the violation of the injunction that was granted against his contact with his neighbors. So his actions were such that the court deemed it necessary to allow an injunction to be in place. And he did violate that. It is a new law violation while out on bond. We do not believe it is appropriate to reinstate the bond. If the court does choose to do so, we would ask that the court order a GPS monitor prior to its relief, as is required in the Justice Laws.
Lives here in Crestview.
He does, Judge, and the only contention, the issue with the neighbor, being on the sex offender registry is not an easy function. It does spark feelings. It is believed that that's where some of the issues dealing with the injunction arose. But he has tried to otherwise be compliant.
That case has been resolved, you said?
It was, Judge, on September the 17th of this year. And he has been incarcerated since August the 31st.
All right, I'll reinstate the bond with a GPS monitor.
And Judge, I do have a proposed order. The typical rate would be $12 a day. Would the court consider it a reduced rate?
Yeah.
And what would that rate be, Judge?
Is he working?
He is not, Judge.
Oh, what's the minimum? $1 a day or something?
I believe so, yes, sir.
$1 a day.
I do have a proposed order if I may approach. It does reference the monitor. Absolutely, the order does contemplate that he would be on pretrial services for listed sex offenses with a GPS monitor to be affixed prior to his release from the Okaloosa County Jail.
All right.
And I'll recall my other case a little bit later this morning, Judge.
All right, don't mess up.
Sir.
Thank you, Judge.
Thank you, sir.
Ms. Glisson? Are you a defense attorney now?
Put my name on the list, Judge, because this is the only one I have today.
Oh, so you
Morning.
stealth,
That's right.
stealthily.
Slide
Okay.
on in.
All right, go ahead. This
Your
is-
Honor, yes, Your Honor, this is Mr. Jacob Price. It's 19 CF 3106. We're here for a competency status hearing. Mr. Price had been previously declared incompetent by the court back in 2020 and March of 2024. We've since had 2 competency evaluations completed. I do have copies for the court. Ms. Rivers is stipulating to the reports that were done by Dr. David Joseph on November 24th of this year, and as well as from Dr. Randy McDonald from October 8th of 2024. Both of those reports do find Mr. Price to be competent to proceed at this time, so I would either ask the court to take judicial notice of the reports that are in the court file, or I can approach with a copy. And Ms. Rivers has no objection to the court reviewing these evaluations and making an independent
I
finding.
think they were in a court file. I
Yes, Your
looked
Honor.
at them, so
Thank
I'll
you.
take judicial notice and find these been restored to competence.
Thank you, Your Honor, and I will follow up. I do, I've just printed out really quick and submit it to Your Honor, the courts, for the court to sign, finding, the defendant has to basically be adjudicated to be competent in writing, so I will submit
All
that.
right. You want-
And if we could set this, because speedy trial's already waived, we are in the process of setting depositions now, so if we could maybe set this for pretrial on Wednesday, February 26th, which is, I believe, the next pretrial, after this one
Okay,
coming up, would that be?
February 26th.
Is that okay, Ms. Rivers?
That's fine.
Apparently, they're having 2 pretrials next
They're
year.
setting 2 different dates for pretrial, so see how that
Inmates
goes.
is on the 26th, I guess. Okay. All right,
Okay.
thank you.
Okay.
Byron Cotton,
Morning, Your Honor.
morning.
Your Honor, we're here on a motion to amend bond conditions. Mr. Paycheck, present, coming forward with the court. Your Honor, we've come before the court in a motion to amend bond conditions based on Mr. Paycheck's inability to obtain employment under his current circumstances. Mr. Paycheck, and I know the court's probably previously had an opportunity to review the motion. Mr. Paycheck was charged with use of a two-way communication device to commit a felony. We had a pretrial detention hearing on this back in June or very early July, Judge. He was charged with 2 counts of child neglect. This was an issue that took place in his home. Law enforcement came. There was a couple hours of back and forth between them. The court ultimately granted bond in this case in the amount of $100,000, which at that time the court said, I know it's high, but we got a lot going on here. My client had provided probably 10 to 15 letters to the court on behalf of him. He's a retired, medically disabled, retired military veteran. The reason why we're really here before the court today, Judge, there were other requirements that he's had to do. There were pretrial services, which he reports to weekly and has had no violations of. He was required to do a psych eval and a mental health eval. He's done those, completed those, and the evaluator found that there were no mental health issues of concern. He also, the reason why we're here today is not to completely get rid of any pretrial sanctions, Judge. My client, as a result of being arrested on this case, lost his business. So he's had to go try to find a job. He was also not allowed to go back to the home. There was an injunction in place at that time. He was supposed to comply with that. He did. That was ultimately dismissed by another court here in Crestview. Essentially what we're asking for is for the court to allow my client to have the GPS monitor removed, keep him on pretrial services, keep the bond in place, not change any other requirements. And it's solely because my client has had to liquidate his retirement account because he's had to now provide for himself a household separately from his family's household due to some bond conditions. And he continues to help provide for the family. So he's essentially attempting to support 2 households. Simply, Judge, he's run out of money and he can't find employment. My client, when I filed this motion, had filed approximately 250 applications for employment, and he's only been accepted for 1 employer, and it's an underwater diving job, which we wouldn't be here but for he can't do that job with a GPS monitor on. He's willing to keep checking into pretrial services, be supervised, no other changes. He's just simply trying to find a way to gain employment. Since that time, and we filed that motion, he's applied for over 300 and has had no acceptances at all. So what we're asking the court to do is one of 2 things. One, either allow him to remove the GPS monitor, require him to keep the bond in place, abide by all other conditions, keep reporting to pretrial services, so that he can get this job and maintain a livelihood to be able to keep paying for himself a place to live and help support his family. Or in the alternative, allow him to move out of the area so he can seek employment elsewhere. I mean, he's got private counsel. He has a $100,000 cash or professional bond. He is certainly not a failure to appear risk. To the extent that there's some worry that, as this court knows, a GPS monitor kind of tracks where someone was after an incident, not doing a lot to prevent someone from doing it. There's other bonds, other conditions in place that are doing that. And so for those reasons, we'd ask the court to consider allowing him to remove the GPS monitor.
All right.
Your Honor, obviously the state is opposed to the removal of the GPS. The purpose of the bond conditions, Your Honor, is to assure that the client appears, but also for community safety. And in this case, the state feels that the GPS monitor is very important to the community safety aspect of this. In this case, Your Honor, Mr. Paycheck is charged with making written threats and verbal threats to the safety and well-being and, frankly, the lives of law enforcement and other agencies that were involved in investigating his case, specifically DCF. And also was found with explosives. So based upon the nature of the charges, the state was asking originally to keep him in pretrial detention at the county jail. The court believed that it was appropriate to grant a bond, and the court actually did put great weight, it seemed, on the fact that he did not appear at that time, that he was armed during the course of these events, during the standoff that Mr. Cotton mentioned. Actually, subsequent to that, analysis of his daughter's phones show there are videos where he was, in fact, armed during this standoff. So I did want to bring that to the court's attention. That is a change in circumstances. So that goes further to the fact that the state believes that Mr. Paycheck's actions were dangerous. We do believe that he is a danger to the community. And we are asking the court to keep that safeguard in place that the court gave us originally, which is the GPS monitor. It does allow the state to track his whereabouts. It does give a modicum of security in the fact that we know where he is and potentially who he might be endangering. So we're asking that that be kept in place for the safety of the community, and that is the purpose of the bond conditions. Additionally, Your Honor, as to not being able to find work, frankly, we do not know where he's applying, but there are jobs out there. He can get a livelihood. There are plenty of people that work with GPS monitors. We have many, many people on supervision that work, so jobs are out there. We do not believe that that would be a good reason to put lives of people in danger. So we're asking that that GPS monitor remain in place based on the threats that he has made and actions that he has taken and why we're.
What's this diving job?
Judge, it's an
kind of
underwater, the diving job is essentially cleaning boat bottoms, where he has to be underwater with the dive gear on to be able to clean the boats.
He's been offered the job?
He has been offered, only job he was offered. Only job that he was.
What company is it, or
What
what
is
person?
Diver's Delight out of Niceville, Florida, sir, Your Honor.
He's got $100,000 cash or professional bond?
He does. And Judge, it's worth noting, he's been on supervision for 5.5 months and has been in full compliance.
All right, I'll let the GPS come off.
Okay,
But I'm
thank
not
you.
going to allow him to roam wherever he wants to. He's
Understand,
still
Judge.
got to
It's a local job.
comply with pretrial services.
Thank you, Judge. I'll prepare a proposed order and send it to the
All
court.
right,
Thank you, Your Honor.
Thank you.
Bo Powell.
Bo Powell for the record on behalf of Tara Overstreet.
All right.
As approaching. Judge, this case, we've previously entered a plea, and we were set here today for the court to impose sentencing. And we haven't agreed upon sentence. We already took the plea agreement's filed, and the score sheet's filed. We just set it today for the court to impose sentence.
Let me look here at my paperwork. Right, you got a copy of that plea agreement? I don't seem to have that in my paper.
I have it, Judge. Essentially, we're going to, well, we've previously pled to count 1 and count 4 of the information. The terms of the agreement was for 3 years state prison with a lien of $400,000, or 12 months to pay, and then to a lien for $400,000. I have it in, if I could approach.
Can I see it?
Yeah, of course.
All right, this was the agreed upon sentence.
Correct. She's previously pled to it.
Have I signed a score sheet already?
I believe you did.
All right.
Yeah, per the plea agreement, yes.
All right, how much time has she served already?
1 day.
All right, well, the court finds, adjudicates you guilty, sentences you to 3 years, Department of Corrections, concurrent on each case. Standard court costs, restitution of $400,000 payable within 12 months of release or it goes to a judgment. And credit for time served, and state's going to dismiss counts 2, 3, and 5, right?
That is correct, Your Honor.
Okay, anything further?
No, Judge.
All right, thank you.
Thank you, Judge. The next matter I have is Bryson Gurney.
Bryson?
We have a negotiated plea agreement.
All right. Mr. Gurney, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God? Sir. Thanks. Can I have the agreement?
Second approach. Gurney would be entering a no contest plea.
All right, Mr. Gurney, you want to enter a no contest plea to the charge, count 1, 2, 3 through 10. Count 1, let's see what we got. Possession of photos of sexual conduct by a child. Count 2. Same charge, correct?
Correct.
Count 3 through 10, same charge. All third-degree felonies, correct?
Correct.
All right.
Judge, this would be a downward departure pursuant to a plea agreement.
Okay, the court judges you guilty on all counts. Count 1, 5 years sex offender probation, GPS monitoring, sex offender designation, no contact with minors, forfeit seized devices, no internet or internet-capable devices, curfew from 7 p.m. to 7 p.m. to 7 a.m., adjustable by probation for work or school purposes without requiring court permission, no conversion to administrative probation or early termination, and all statutory requirements under Florida Statute 948.30, court costs $515 and $151, crime against minors fee, cost supervision $40 per month. Count 2, judge guilty, 5 years sex probation, consecutive to count 1, count 3 through 10. And count 2 is a judge guilty. Count 3 through 10, a judge guilty on all counts. 5 years sex offender probation, consecutive to count 1, and concurrent to counts 2 through 8 and all the other counts. And that's it, I think, correct?
Judge, just to clarify, the curfew's 10 p.m. to 7 a.m.
Right. 10 p.m. to 7 a.m. Is that right? Okay. Anything else?
No, sir.
Y'all have any objection to that? All right, waive them and $1 a day.
Thank you, Judge.
That's no contact with minors, correct?
That's correct.
Your Honor, may I we'll just order for Jacob Price. This is the order adjudicated competent.
Yeah, all right.
Does not have an objection.
All right, thank you.
Thank you, Judge. The next matter I have is Cynthia Miller.
All right, who is this now?
Judge, this is Cynthia Miller. Case number 24 CF 149.
Cynthia Miller.
It
I have it as number 75 on my docket, Judge.
may be on the docket under Mr. Williams still. We filed late yesterday.
Was under my name, Judge.
Okay.
Mr. Powell called me yesterday on my way to the jail and let me know that her mother had retained him. I had other people to see, though. It's okay.
All right, I got it. What you want to do?
Judge, we're asking for just the next available VOP date or miscellaneous date.
What is that? 9th? How about January 9th?
That would be great.
Okay, thank you.
Thank you, Judge. Thank you, Judge. Have a good day.
Good morning, Your Honor.
Morning.
The only thing I have on the docket this morning, Your Honor, is Dwayne Armsby, 24 CF 1431. We're on the docket for a motion to exclude witness Savannah Odom. It's been about 3.5 months since we were unable to serve a subpoena on her. There's no forwarding address. We've heard no update from the state for contact or anything else.
Yes, Judge. The state has been attempting to contact Savannah Odom. Ms. Odom, made a call out for her this morning. She is not present. We have sent our investigator out to find her. We're not able to find her. Her testimony would be necessary in this matter, and so due to that, at this time, the state will dismiss the charge.
Any objection to the state dismissing the charges?
None at all, Judge.
All right, thank you. Send me an order or file an NOLPROS on that.
Yes, sir.
We'll send an order for the order to exclude just to perfect the record, but the null process should clear up the rest of that.
All right, thank you.
Judge.
Is there any other private attorneys I can't see out there? Pardon? We got an officer out there. What case are you here for?
Is here, Your Honor, for Mr. Emerson. Could we hear that case?
I'm ready for Mr. Emerson, Judge.
All right. Yeah, I just want the officer sitting around all day long.
Thank you, Judge.
Unless you want to sit here and watch this great exhibition of legal skills. All right, what we got? Was that Emerson?
Yes, Your Honor. Dustin Emerson, 24 CF 784, Judge. So if that's what you'd like to do, just sign right there for me. Today's date, please. December 5th. Time may approach, Your Honor.
Yep.
Score sheet included, no objection.
All right, State of Florida versus Dustin Emerson, 24 CF 784. Mr. Emerson, would you please raise your right hand to be sworn? You swear the testimony you give for his court's the truth, so help you God.
Yes, sir.
Okay. You want to enter a admission that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I did.
Anyone threaten you or force you to sign this form?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Mr. Gibbs did for you on your case? Court finds that admission freely and voluntarily entered, court accepts it, adjudicates you guilty, revoke and terminate, sends you 36 months, Department of Corrections, credit for time served, $100 VOP fee, $150 PD fee, all outstanding monies to collections. Okay?
Thank you.
Thank you. All right, let's call them.
Chelsea DiCarlo.
Mr. Carlo, this is, you're here on a violation of probation. Is there an offer from the state? You don't have to.
Yes, Judge. I believe there, Ms. DiCarlo has made significant inroads on the restitution that she owed. There is, I believe the recommendation from probation is to reinstate for approximately 1 year left that she would have to see if she can finish out that restitution. And that would be the state's offer.
Just admit and reinstate and finish it out?
Yes, sir. I believe she has somewhere around $4,000 left in
All right.
restitution owed.
Does the rest go to judgment if she can't make it all? Yeah.
We would request that, Your Honor. It is a public funds. It wasn't like she stole money from a private individual. She just came to term, or her termination date's the 7th, and the restitution hasn't committed any new crime.
All right. Ms. DiCarlo, you want to enter an admission? With that, I'll reinstate and just finish out your term.
Yes, sir.
Make whatever restitution you can. If you can't, then it'll go to a judgment against you. You understand that?
Yes, sir.
Would you raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God. You want to admit that you violated probation? Anyone force you or threaten you to enter this admission? Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today? Court finds admission freely and voluntarily entered. Court accepts it, revoke and court will reinstate, finish out your probation and,
We'll have to reinstate and extend it for 1 year from her original termination date,
okay.
which is
The court's gonna,
today's.
yeah,
So we'll go 1 year from that with the condition to keep us from coming back, monies to a judgment
yeah.
at the end of her new term.
I'll reinstate for 1 year from the original termination date, continue making your restitution. If you can't finish it out, it'll go to a monetary judgment. Okay? All right. Thank you. Yeah.
Christopher Estrada.
Everyone that's coming up here, you have the right to an attorney if you decide you don't want to accept this offer from the state. Is there an offer for Mr. Estrada on a violation of probation?
Yes, sir. Mr. Estrada went on probation in both counts in February of this year. The violation report alleges he's done nothing towards his DUI school, victim impact panel, and no community service, and that he is employed. The state's offer is actually an alternative offer. If Mr. Estrada can show proof that he will take those conditions seriously and actually enroll in the DUI school and the victim impact panel and begin his community service, we could reinstate the probation, but if not, the state's offer would be 9 months county jail.
Your Honor, I have already enrolled in the DUI program. I have a paper. I just recently was able to do it financially. It's been hard getting rides to the locations. I've been working and responsibly attending my job, making sure to keep myself out of trouble. I've abided by all the probationary check-ins and things.
When's this probation end?
I was under the influence that it was 2 years, and I thought I had more time to get these responsibilities done, but apparently it's supposed to be within a year.
Your Honor, is this, Estrada?
Yes.
He is on probation with us till February the 25th of 2026. He just had a DUI 1129 within that.
Yeah.
So if you want to, if
Why don't we just-
reinstate him, he can have the entire period of time of February the 25th of 2026 in which to complete the conditions.
Why don't we just do that?
And then he'll just, but he needs to do them. I mean,
Yeah, well,
I know he's been told to do them
I-
numerous times.
I'll modify your probation to let you have the 2 years to pay those and do those things, but, you know, get them done. Otherwise, you're probably going to go to jail for a year or more.
Yes, Your Honor.
Okay, so,
I'm currently enrolled in the program. I just have to,
all right, so I'll modify his probation, let him have the 2 year, the total term of probation, which is what we do in almost virtually every case anyway, to pay his monies and get those programs done.
His money is and complete the DUI conditions during
Yeah.
the term of the felony probation.
Right. Okay?
Is this an admission to the violation, Judge?
yes, Your Honor.
I don't think we need to admit, I mean, he's just a modification of it. So if he, I'm going to take it as a pro se motion to modify. And, of course, if you don't do it, then you'll be facing a violation of probation, okay?
I understand, Your Honor. It's time to get things done.
All right, thank you.
Bias Hendricks.
All right, you hear Mr. Hendricks on a violation of probation. Is there an offer for him?
Yes, Your Honor, the offer is an adjudication, 4 months county jail with credit for time served. Mr. Hendricks pled to misdemeanors. My understanding from probation is that he did not do his community service or pay the $665 in court costs, and he's 24 and he's not employed.
So the offer is 4 months county jail?
Yes, sir.
You want to take that, or you want an attorney?
I want an attorney.
Okay, I'll appoint public defender, represent you.
Judge, I'm going to enter denial on his behalf for right now.
I'll set it for January 30th.
Yeah, Judge, that'll be fine. That'll be fine. I'm just wondering why 4 months on a largely financial.
Y'all can come back and talk about it.
Okay, well, you and I'll talk later.
What's the next,
If he can
January
get started, that would be a good idea.
30th? Okay.
On, Judge, you said January 30th?
An offer for Mr. Lawson?
Yes, Your Honor, for an admission, the state would ask to modify probation, extend it 12 months to complete the outstanding requirements, and he can early terminate once he's done.
I paid it already.
Has he completed everything?
All right, we'll bring you back in a minute.
If I may just say, according to the report, he failed to complete the anti-theft course, and,
I'll check on all of
okay.
it. I know Daniel.
Okay, just have a seat back there, Mr. Lawson. Y'all seem to have, y'all know what page he's on?
Page 5.
Oh, Justin James Cox, okay.
Yes, sir.
All right. You're here on a violation of probation. Let's see if the state has an offer for you. If you don't like it, I'll appoint public defender to represent you, okay?
Yes, sir.
Your Honor, the offer in both this VOP as well as the new law violation felony would be minimum guidelines, 32.1 months, Department of Corrections.
You want public defender?
Yes, sir.
I'll appoint public defender to represent you on both cases. Set it for January 30th.
Can I ask another question?
Yeah.
Is there any way I can get, I don't like is that pre-trial release? Because my granny's passed away and she.
We have to ask your attorney to file whatever motions are appropriate.
Sir, I won't be representing you myself. What's your name?
Justin Cox.
All right, Mr. Cox, I'll tell your attorney to come out to the jail and see you.
All right, next.
Denzel Green. Denzel Green. 13.
I got, all right, Mr. Green, you're here on a violation of probation. Let's see if the state makes you an offer. If you don't want it, we'll appoint public defender, okay? Okay. What, is there an offer for Mr. Green?
Yes, Your Honor, Mr. Green has this violation of community control as well as one other felony case. It is a third violation. The state would ask for 9 months county jail with credit for time served, revoke and terminate, send any money owed to judgment. And that would be a global offer of both cases.
And his other cases besides the VOP is what?
Judge, that's 20 CF 2301. I believe that's been, the clerk has set that in the south end with Judge Brown, but
Oh, I
We
can't
would
take
ask-
it. I can't take it. I can't take a plea on that if
could
it's.
we do could you order a transfer of that case? Because Mr. Green was last sentenced in the first violation of probation in this court. So we would ask that that case get transferred up here.
I mean, I have no problem giving him that, except it's not my case. You're gonna have to do it in front of Judge Brown. If that's what you want to do, do you want me to appoint a public defender? Are you interested in taking that? Okay, I'll appoint public defender. Then y'all can work out the logistics of getting it transferred to Judge Brown. January, we'll set it for tentatively January 30th. If
Right,
if
and
it
we'll look
goes,
into that
it'll
transfer.
change. It'll change to I don't know what judge. I guess a Judge Stone or Judge Clark. Stone. Stone. Judge Stone. Okay.
Yeah, we'll look into that, Judge. Thank you.
All right. Thank you.
Mr. Simmons. Bradley Simmons.
All right, Mr. Simmons, you're here on a you represent by. We're here on a violation of probation.
Yes, sir.
Is there an offer for him? If you don't want to take the offer, you don't have to, and I'll appoint public defender, okay?
Yes, ma'am. Yes, sir.
Is there an offer for Mr. Simmons?
I believe there was an error on our docket. We have 3 cases that, according to my research, should not be open.
Well, Your Honor, as a friend of the court, because I do represent him on a new law case, I did pull his judgment and sentence. He was never placed on probation on 13 CF 1826, therefore he can have no violation of probation. He was never placed on probation on 13 CF 2974. He was, on both those cases, he was given the maximum sentence of 5 years DOC. And then he was never placed on probation on 14 CF 2670. He was given the maximum sentence of DOC. The only case he was placed on probation was 14 CF 2669. He was placed on 5 years probation on counts 1, 2, and 4, and that is looking at the judgment and sentence of the court.
Okay, so,
And I would seek appointment on case 14 CF 2669, and I would ask the court to close the other 3 cases because he was never placed on probation in those cases.
The other 3 from 2013 and 2014, there is a new law violation from 2024.
all right, well, I'll appoint you and send me an order
Okay.
that clarifies the record so he doesn't get unfairly hit with VOPs that he was never placed on probation. Okay?
Yes, sir, and that'll give the state the opportunity to reach out to the victim in this 2014 case
All
as
right,
well.
it might work out for you, Mr. Simmons. I'm giving you a public defender. She's going to see about 3 of these cases you can't violate because you weren't ever put on probation, okay? And she's going to check and see about the other one. It may work out very favorably for you, okay? All right, January 30th, thank you.
All of the pro se except
I'm ready.
Later.
Yeah.
And Judge Brandy Merrifield, on behalf of Chad Blada, back before the court in 22 CF 941, it is a violation of probation. Judge, where we are, the state made an offer that Mr. Blada was willing to accept. We anticipated being able to do so. So his case originated as a felony, but he pled down to 2 misdemeanors for consecutive probation, although supervised by state probation. The state's offer was for the remainder of his term to be on community control. He terms out in September of 2025. It's my understanding he doesn't have any other conditions outstanding other than time. I've been informed by probation that because he pled to misdemeanors, they can't supervise him on community control, but that's certainly the intention of the state, that he be on house arrest style sanctions. So I'm uncertain what to do at this point because he would have accepted that offer so that he could get released. He's been in since the 20th of November.
So he's entered pleas to misdemeanors?
He did, Judge. He pled down to 2 misdemeanors for consecutive probation, and the state.
Don't we have probation supervisors for misdemeanors? I mean, what's the problem?
The issue is that the state wants him to be placed on community control, and it's my understanding that probation cannot supervise him on community control because they are misdemeanor offenses, and Mr. Berry may be able to help clarify.
I checked on that 2 or 3 times. That's always been my understanding, that they can't be placed on community control for a misdemeanor with the Florida Department of Corrections. I have checked on that extensively this morning, and everything I'm getting back from my office is he can't be placed on community. I even went
Yeah, that
through
sounds like
probation with the condition to be on
why don't you just,
CC sanctions, and they shot me down on that, so.
We'd also discussed, calling it house arrest instead, but that functions the same as community control, which I was told was not allowed.
Your Honor, I need to ask for a continuance at this point because I had a discussion with the victim. There are victims involved in this case, and at the very least, they would want to be heard on a resolution. I represented to them, and they agreed to the community control, but this morning, I realized that it's not possible, so I need to have a chance to discuss with them and give them an opportunity to be present.
isn't the community control like you got to stay at the house unless you're working?
That is correct.
Correct, Judge. Mr. Blada would be happy to do so. Just so that the court is aware, this is a violation of simple battery misdemeanors. The allegation is third-party contact, where he may or may not have made a statement against the wife's paramour.
Just something about he have a curfew?
He didn't previously, but he certainly could, with any exception for work
What about
purposes.
this? Just a curfew of whatever. except for work time, he'd have a curfew. How about that? Can y'all do
Officer
that?
Can you do the drug offender probation on misdemeanors? Yes, with the curfew?
He can be on drug offender probation.
Okay.
For a misdemeanor.
So even though you don't
That would have a
drug
curfew?
If the court orders it to.
You want to do, is that okay for you?
Yes, I need to add, though, Your Honor, that there has to be no contact whatsoever with the victim. And it wasn't just a third-party contact. It was a violent contact by language, but it was violent.
Okay.
He made threats. And there are allegations that he's using the children's kids to share those threats.
Judge, that does
The
go
other
both
party.
ways. I don't necessarily want to have an evidentiary
All
hearing,
right,
but that goes both
you
ways.
gotta, I'll send me an order modifying it to a curfew.
Okay. And can I, even though there is no allegation of drug abuse, I think I do need to call it drug offender probation with a curfew just to satisfy
Yeah.
probation, so I'll add
Yeah.
that language.
And no contact at all with the victims.
It would also be admitting the violation. There would be an adjudication, a $100 VOP fee, and I believe that was all.
Yes.
I'll send an order today, Judge.
So do we need to put him under oath to admit?
I think we do, Judge.
Mr. Blada, would you please raise your right hand to be sworn? Do you swear the testimony you give before this court is true, so help you God?
Yes, sir.
You want to admit that you violated probation?
Yes, Your Honor.
You want to force you to threaten you to enter this admission?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work Ms. Merrifield has done for you on your case?
Yes, Your Honor.
Court finds the admission freely and voluntarily entered. Court will put him, modify the probation to drug offender probation with the curfew to allow him to go to work and no contact at all with the victims in any way.
I would ask from 7 p.m. to 7 a.m. curfew.
All right, 7 p.m. to 7 a.m. curfew.
May be adjusted by probation for work purposes.
Yes.
Perfect. I'll send you an order, Judge.
Right, you may not have a nice, soft-hearted judge in the future, so don't mess up.
Thank you, Your Honor. I appreciate that.
We appreciate the court exploring that with us. Okay?
Thank you.
Okay.
One second, Ms. Flowers, let me check on some.
Your Honor, I have a few out of custody, if I may.
I want to take about a 15-minute break. Okay.
Your Honor, if I can, I checked on Mr. Lawson right here, that didn't do the anti-theft course and didn't pay the monies. He has since done all those things, and we're good with him terminating. We have
State asks the court
documentation with all that.
to dismiss the violation of probation.
They want to dismiss the violation. Do you have any objection to that? Okay. You're free to go.
DOP dismissed and probation terminated, correct?
Yeah.
Yes, thank you.
All rise, please.
Thank you all.
15, 20-minute break.
Okay, you should be released today. Unless you have anything else.
I could have gotten that, sir. Thank you.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products
all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at your CrestviewAgent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Matthew D. Murphy. Judge, we've been working on trying to get this resolved. It looks like what we're going to wind up doing is a deferred prosecution agreement. The state's going to draft that up and send that out. I think they need to talk with their victim first, though.
I do need to talk to the victim. If the victim does want to be heard, then we wouldn't be able to do it in writing outside of the presence of the court. Then we would need to come back to court. But that is the state's intention at this time.
We're trying to get it done where they don't have to come back, though. So, Judge, if you'll give us another date, hopefully it will be resolved by then. But I need to get him back to work, and his mother's here, and it looks like she's on duty, so I need to get her back to work.
What about
as well.
January 9th?
Do you think that's enough time? Yeah. All right, that's fine with me, Judge.
All right.
Yeah, January 9th.
Sounds good, thank you, sir.
All righty.
Morning.
I've got one out of custody, if I could call him first. Dalen Kendall. Mr. Kendall, if you could approach. This is Dalen Kendall in 23 CF 2607. We have reached an agreement, but we just need to reduce it to writing and go over it a little bit more. So the state has said they'd leave that offer open until the 30th, if we could set him on that date.
All right, December 30th.
Thank you. The rest of mine are in custody. This is David Joseph Creech before the court in 24 CF 2053. We've reached an agreement. If I may.
All right.
Actually, we've gone over the agreement, but he just needs to quickly sign it. The top line. Mm-hmm. Not today. File motion.
This is State of Florida versus David Creech. Mr. Creech, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
Thank you. You want to enter a no contest plea to habitual traffic offender, driving license suspended or revoked, first degree misdemeanor, failure to have insurance, first degree misdemeanor, and possession of paraphernalia, a first degree misdemeanor, and the state's going to drop the possession of controlled substance felony.
That's correct, yeah.
So you want to enter a no contest plea to those charges?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
Sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers did for you on your case?
Sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 2, a judge guilty, sentenced to time served. Count 3, a judge guilty, sentenced to time served. Count 4, judge guilty, sentenced to time served. $270 court costs on count 4. Count 4 was a judge guilty, sentenced to time served, $270 court costs, $100 cost of defense. In count 1, the state's going to file a null pros. Okay? All right. Thank you.
Can I just dismiss it on the record per the agreement?
Okay.
With the-
We
He's
would
pleading
ask
only to one, the 1442.
1442. We're going to set on 1230, if that's. Yeah, he only.
So
entered a plea.
this was 24 CF 2053.
Correct.
Okay. All misdemeanors, right?
Yes, Your Honor.
Okay. All right.
Come this way, Mr. Mitchell. Come towards my voice. Okay. Here's a podium. Okay.
All right.
This is the agreement we went over that I read to you and we went over. Can you see that top line to
All right.
make your signature? Thank you.
Okay.
Thank you. All right, Your Honor, this is Ronald Patrick Mitchell in 22 CF 831 and 24 CF 1240. We have reached an agreement, if I may approach.
All right. Mr. Mitchell, would you please raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God?
Okay.
Okay. This is State of Florida versus Ronald Mitchell, 22 CF 831 and 24 CF 1240. Mr. Mitchell, you want to enter a no contest plea to battery on an officer, on one count of battery on an officer on both cases, a third-degree felony, correct?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Ms. Flowers, go over your rights you're waiving by entering this plea with you. In other words, you have a right to a trial.
Yep.
You're waiving those rights, okay?
Okay.
Has anyone forced you or threatened you to enter this plea? You've been forced or threatened by anybody to enter this plea?
Other than going blind?
Okay.
Okay.
Other than going blind, anyone forced you or threatened you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Nope.
Are you happy with the work Ms. Flowers did for you on your case?
Absolutely.
Court finds the plea is freely and voluntarily entered. Court accepts it. In 22 CF 831, you're judged guilty. Since the 12.1 months Department of Corrections with credit for time served, concurrent with 24 CF 1240. 615 court costs, $150 cost of defense, all to collections. In 24 CF 1240, you're judged guilty, sentenced you to 12.1 months. Department of Corrections, concurrent with the previous case, with credit for time served, 615 court costs, $150 cost of defense, all to collections. Okay, so you're going to go down there for a little while and be done.
And Your Honor, Mr. Mitchell just wanted me to ask the court if you could order he be transported to prison as soon as possible.
Yeah. Send Mr. Mitchell to prison as soon as possible so he can get some medical help.
I'm already in prison, Judge.
Okay, well, we're going to send you to a better prison.
Okay.
Outside of the county jail, too.
State prisons are better than county jail.
That's what you wanted me to ask, right?
Right.
Okay.
Right.
Okay,
Thank you, Judge.
Judge, this is a downward departure based on the legitimate uncoerced plea.
okay. Downward departure on a plea bargain. Thank you, sir. Good luck to you.
All right. Thank you, Ms. Flowers.
Your Honor, this is Mercedes Feigl in 20 CF 1209. This is a violation of probation. I believe the state has an announcement in this case that they're going to, Ms. Feigl, dismiss the violation. I think the announcement is that they're going to dismiss the violation and terminate supervision today. She's completed everything.
That's correct, Judge.
All right, they want to dismiss your violation. Any objection to that? Okay.
And
Thank
terminate
you.
probation.
And terminate probation. Thank you.
You're good. You'll have to go back and they'll process you and you'll be released.
Sykes?
This is Stephen Sykes before the court in 23 CF on this side. 23 CF 79. This is a violation of probation. We would enter a denial and ask to be set for the next miscellaneous date.
January 9th.
Thank you.
Okay, thank you, sir.
I'll see you. this side. I'm right here. Thank you. That's just their rule. Okay. This is Anthony Weeks before the court. He was originally set for a bond hearing today. However, I was recently appointed on the 25th and haven't had the chance to prepare, so we would ask to continue his case.
Ma'am, can I just plead up? Waiting all this time.
I would not advise that, but I would not advise you to do that.
All right, you want to reschedule it for December 30th or something like that?
Yes, Judge, that'd be great.
Okay, thank you.
I can't plead up to him right now.
He's asking if he can plea up to the, you would be doing that on the, against the advice of counsel. And
Your Honor, I just really want to take care of this today and get this out of the way.
well, you're facing a prison sentence, so.
I know I am, ma'am, and
I would strongly advise you not to.
Well, I don't know what, there may be some offer that you don't want, or,
it's not that, sir. It's I may have a bracelet gone is what the violation is when the bracelet monitor was faulty.
Well,
that sounds like a defense to me, so I'm gonna not take any plea, because you may be waiving, you may have a valid defense, you may be found not guilty, if that's what you're wanting to say, so.
Yes, ma'am.
Okay.
December 30th, thank you.
Thank you, sir. Have a good day.
And that's all I have on today's docket, Your Honor. Thank you.
I have some out of custody, if I may, Judge.
Okay.
Your Honor, first out of custody, I have Ms. Regina Alford.
Where is she?
Ms. Alford? Your Honor, Ms. Alford is present approaching. Tim Gibbs on her behalf. Judge, this is 24 CF 1313. We are here for a motion to modify pretrial release conditions, mostly really only to remove the GPS monitor that was added to her bond conditions by the court when the court lowered her bonds previously this year. She is scheduled to get an MRI for health reasons and involving injuries from a crash that happened a few years ago that her physician once ordered in order to ensure that her care is optimum. Because that GPS monitor is electronic and she's going into an MRI, that could cause complications. We're asking the court to remove the GPS monitor as a condition of her bond. She regularly is in contact with my office and is regularly in contact with any updates as far as where her location is, as well as her phone numbers. So there's no reason to believe that she would flee or that she would be a flight risk. And she would be remaining in the local area as well.
What does the state say?
Judge, the defense attorney is correct. This defendant was before the court on August 29th on a motion to reduce bond, and the court did reduce the bonds from $5,000 per count to $2,000 per count signature, and at that time ordered the monitor. So the state's position is that the monitor is required. If she has a date certain for an MRI procedure, I have not seen that documentation, but I would suggest that that documentation to limit any time that it's removed be provided to the court so that and that it go right back on directly after that procedure, but we would need to see that documentation.
What about that?
Can you provide me a documentation? Your Honor, if she can provide documentation as to when that MRI is scheduled, so
All
we
right,
can
then.
craft an order around that.
Let Ms. Turner see it and then prepare an order, if you agree. Just to take it off while she had, for that day, and then have it put back on.
And who does the removal and the placing back on?
I believe that would be pretrial supervision, since that's who's supervising her now.
Okay. I'll have to talk with them and add something in the order about that timeline.
Yeah.
Yes, sir.
Yeah.
Okay, thank you.
Sounds good, thank you. Not right now, so give me a date for when that's scheduled.
Okay, next.
Get it scheduled and get me a date so we can send that.
Mr. Gibbs, did you get the updated offer in Ms. Alford's case?
Yes, I did. Your Honor, next out of custody, I have Mr. Eric Allen. Your Honor, we've reached an agreement on Mr. Allen's case. Does the state still have that written plea agreement?
Yes.
Mr. Allen, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir.
Thank you. You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it, revokes and terminates probation. $100 cost of prosecution, $150 PD fee, all due within 180 days or to a judgment and adjudicated guilty.
Thank you,
Okay?
Judge.
Thank you.
You good to go? Cool. Thank you. Your Honor, next out of custody, I have Ms. Curry, Courtney Curry. Your Honor, Ms. Curry is present in 24 CF 1965. This is a violation of probation, arraignment judge. If I could have just one moment.
Yeah.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of 11. $1.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law. 850-306-2667.
Background Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're
All right. Let me see Miss Flowers again. I need to see Miss Flowers. Miss Barrickman or Brickman? Barrickman? Brickman?
interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Okay.
CQ Roofing, your hometown roofer since 19...
You can't believe that behind the scenes commotion when you just suddenly, well, let's just do something different with the jail and the Zoom and the court clerk. It's just, we try to do the best we can, but I understand. Okay, yes, sir.
Thank you, Your Honor. Back on the record for Ms. Courtney Curry, 24 CF 1965. Tim gives on her behalf. Judge, she would like to admit her violation today to reinstate her probation so that she completes a substance abuse evaluation and treatment. She actually has an appointment tomorrow scheduled at Bridgeway. And
she wants to admit?
Yes, Your Honor.
All right, Ms. Curry, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
You want to admit that you violated probation? You want to admit that you violated probation? You want to?
So that you get reinstated, yes.
You want to admit that you violated probation?
I think I'm trespassing.
Yes. Yeah, it was.
Has anyone forced you or threatened you to enter this admission? Is anyone making you admit?
Is anybody forcing you to enter this admission to reinstate? No.
Has she got a hearing problem, or she just doesn't understand what we're doing
She
here?
might be having some difficulty. She might be a little nervous, Judge.
Nervous?
I can't hardly hear.
I think you have, okay.
I have problems here.
That's no problem. I just need to know whether you, is anyone making you admit that you violated probation?
Is anybody forcing you to? No.
No, sir.
Okay, violation, court finds freely and voluntarily entered. Court will what? Revoke and terminate?
It's reinstatement, Judge, to complete substance abuse evaluation and treatment, adding $100 cost of prosecution, $150.
All right, reinstate, do a substance abuse evaluation, $100 cost of prosecution, and tell her where to go so she understands what that is.
There are time limits also to this. Probation amended their recommendation to give her some more strict requirements. That substance abuse eval has to be completed within 30 days of today, or 30 days of her
And you've got that
reinstatement.
appointment tomorrow, right?
And then she has to enroll in any recommended treatment within 30 days of that intake. So she really needs to.
Okay,
All right. Shouldn't be an issue. She has an appointment scheduled tomorrow at Bridgeway, Judge.
all right, thank you.
Thank you, Judge. Just meet with probation so you can get rescheduled and
Who put that picture of me up there? That. Huh?
John Gentry, I think.
All right. And it's bald-headed too, just like me.
Your Honor, next out of custody, I have Mr. Jad Franklin. Your Honor, Mr. Franklin is present and approaching in 24 CF 1153. We had set this for a status hearing this morning, Judge. We had filed a sworn statement from the alleged victim wanting to drop the charges, wanting to recant her statement. Speaking with the state, I believe the state wants to review some medical records with the alleged victim before they make their decision on whether to dismiss the charges or if we need to set this for a trial or any other motions.
Yeah, January 9th.
Can we set him for December 30th, Judge? It's a new law, so it'd be pre-trial.
All right. December 30th. Thank you, sir.
That they have to do all that. Oh, yeah. Get an appointment. Call me, get an appointment. That's all I have out of custody right now. Thank you, Judge.
Ms. Rivers?
I don't have any out of custody.
Mr. Williams?
Judge, I do.
Okay.
Sorry, Judge, I'm shuffled. Cody Hinesley? Judge, Mr. Hinesley's out on a conditional release program, having found to be incompetent. The new, or the replacement for Mr. Barnes, my understanding from talking with Cody is that she's got about another month before she's going to have, or is going to be credentialed and will be able to render an opinion. So I think we're going to, what I suggested to Mr. Hinesley was give her also time to reevaluate him, set it out 2 months.
Any objection to
No,
that?
no, Your Honor, no objections.
All right, what about February 6th? How about that?
Sounds fine with me, Judge.
Okay,
All right, Judge, thank you very much. Hopefully, we'll have a report from her by then.
all right, thank you.
Okay, good. Judge, the next one that I have is Jason Howell. Judge, Mr. Howell was scheduled originally for trial and then to enter a plea. We dismissed the jury and did not come to court on that date. He had signed the plea agreement. I'm going to ask that the court allow him to go ahead and enter that plea today.
All right, Mr. Howell, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, I do.
Okay, thank you.
I just couldn't see what you were looking at.
You want to enter a no contest plea to the charge of,
They're going to dismiss count 1, Judge, and then the plea would be to count 2, which is the DV battery.
all right. So you want to enter a no contest plea to the charge of domestic violence battery?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Do you wear the rights you're waiving by entering this plea?
Yes, sir.
You want to force you or threaten you to enter this plea?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 2, judge guilty, sentence of time served. Standard court cost $100 cost of prosecution, $50 PD app fee, and $100 PD fee. And the state will dismiss the count 1.
That's correct.
Correct? Okay, thank you.
Thank you, sir. Thank you.
We got a capious for him. What was that on?
That was
Failure
because he
to
didn't show
appear.
up in court, Judge.
Okay, well, okay, I'll recall that.
Thank you,
Thank you,
Judge.
sir.
Okay.
Judge, I believe that's all I have out of court. Is anybody else here for Jay Williams? Yes, sir. What's your name? Wesley Moore. Come forward, Mr. Moore. Judge, I don't have a file on Mr. Moore. It may, we may be working off an older docket. Madam Clerk, what's Mr. Moore supposed to be here for?
I don't have him on the docket. I got Dwayne Moore.
Sir, honestly, I don't recall. If you'll give me a minute, I'll try to look it up for you. You're apparently not on the docket for today. He said Wesley, I thought. Yes. At 1:30? Okay. Judge, since he's already here, does the court...
Yeah, come on up. Come on up, Mr. Moore. Right, he is here on arraignment, charged with what?
Judge, state filed on possession of a controlled substance, methamphetamine, and possession of paraphernalia. That's a third-degree felony and a first misdemeanor.
First degree, all right.
That's correct. FDLE has come back on the methamphetamines. The state's offer is an adjudication, 3 years probation, substance abuse evaluation and treatment, court costs, random year analysis.
You want to do that? I'll appoint the public defender to represent you. Set him for retrial February 24th.
Thank you, Judge. All right, Mr. Moore, you need to make an appointment, come into my office, okay? And we'll talk about the case then, okay?
All right. Next.
Your Honor, this is Terrence Parker before the court on, I'm sorry. I was sleeping this morning. This is Nathaniel Parker before the court on 23 CF 1527, 24 CF 581. I filed a motion to clarify bond amounts. Your Honor, he had violation of probation. Your Honor saw him at first appearance. You gave him $1,000 signature bonds. The jail will not let him out. The jail says that there is a count 2 on one of the violation of probations, even though it wasn't listed in your paperwork. And so we're asking the court to just do a blanket $1,000 cash professional on any counts that the jail may recognize.
I'm not showing this on my docket. This is Parker
Yes.
and the 9 a.m. docket.
Did notice of hearing?
Is it Nathaniel Parker?
Yes, Your Honor.
40, page 16.
So what was the charge that he didn't get a bond on?
So according to the printout from the jail, I show you did, but they're saying that that you did not grant a bond on probation violation, possession case. I mean, it shows in the first appearance paperwork you did, but they're saying that you didn't.
Nathan Bryan.
Nathaniel Cornelius Parker. If I may approach, Your Honor, I mean, it shows right here, $100 signature on the same thing, but the front page is what the jail printout is, and they won't let them out.
Yeah, I found the key.
Your Honor, prior to him being arrested for the new charge, he was complying with the terms and conditions of supervision. He got a new, I believe it was driving while suspended.
That's correct, Your Honor, and he did get a cash professional bond on that
We don't have any
case.
problem with.
All right, just prepare me an order, $1,000 signature bond.
Thank you, Your Honor.
Okay?
Parkinson?
Your Honor, this is Adam Parkinson. He's before the court on violation of probation.
Okay.
Your Honor, he's indicated that he would like to enter a plea admitting violation of probation. But this would be a plea to the court. I have discussed it with Ms. Basso.
And Your Honor, at this time, Mr. Parkinson does have a 10-year suspended sentence. The state is not prepared to go forward on a formal sentencing hearing. We would be asking for the 10-year suspended, though.
You have court on the 26th.
We have cases on the 26th?
We're told.
Pardon?
So we're told, Your Honor.
Yeah, there was some other, my JA said there's some other case. I guess we need to set on 26 if y'all going to be here. I can't
Tell us
remember.
to, we'll be here, Judge.
I can't remember what it was, but, okay. All right, this is Adam Dale Parkinson, 17 CF 3022.
Yes,
Mr. Parkinson, would you please raise your right hand and be sworn? You swear the testimony you give for this court's the truth, so help you God?
Absolutely, Your Honor.
Okay. You want to admit that you violated probation?
Yes, sir, I did.
Are Are you aware of the rights you're waiving by entering this admission?
Yes, sir, I'm aware.
Anyone force you or threaten you to enter this admission?
Oh, Your Honor.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds admission freely and voluntarily enter. Court accepts it. Will set you for December 26th sentencing. Okay? Christopher Lee Porter.
Your Honor, he did not have a plea offer. He does now. I just need to go over it with him real quick.
All right.
All right. You need to sign it right there, okay? And Your Honor, I did have to handwrite it because it was a last-minute thing.
Mr. Porter, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God? You want to admit that you violated probation?
Yes.
Are you aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers did for you on your case? Court finds the admission freely and voluntarily enter. Court accepts it. Sentences you to 2 years of community control, bars to bed, comply with Phoenix House. That was on count 1. Count 2 and 3, 1 year concurrent community control with each other, and count 1, $100 cost of prosecution, $100 PD fee, $50 PD app fee, in 24 MM 3132. Concurrent 1 year community control, 1 year and they do community control on misdemeanor? I think we just went through that.
No, we can't.
Okay, what about 1 year probation?
But it's going to be served at the same time as the community control.
Absolutely.
Yeah,
Okay.
1 year
Okay.
probation. Concurrent with the count 1 and 2. $50 cost of prosecution, $50 PD fee. Any previously ordered restitution will be completed in 24 CF 1957.
And waive any monthly probation?
And waive monthly probation costs. Okay?
And he has been screened for?
Yes, he's been approved.
Phoenix House.
Adjudicated guilty on all counts.
So any conditions on the felony, the misdemeanors can be done during the period of supervision on the felony?
Yeah.
So we have counts 2 and 3 from.
Are they? Yeah. Okay. Apologies.
Okay.
Okay.
All right, time served then on those cases.
On the misdemeanor?
The misdemeanor counts of the felony.
Yeah, I got you.
Your Honor, this is Pablo Portugal. He's before the court on 21 CF 748. Thank you. 21 CF 749, 21 CF 750. We've reached an agreement in this matter. If I may approach.
All right. Mr. Portugal, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, Your Honor.
You want to admit that you violated probation?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission?
Yes, Your Honor.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Sentences you to modify probation to 2 years community control. Concurrent on each case. $100 cost of prosecution, $100 PD fee, waive cost of supervision, $50 app fee, PD app fee. Complete all original terms and conditions of the probation. Okay?
Yes, sir.
Thank you.
Your Honor, my client did make a counteroffer to the state, so I just need to go over her response. Need to sign it right there.
All right, Mr. Reynolds, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God? Okay. You want to admit that you violated probation? Did you read and sign this plea and sentencing admission form? Are you aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers did for you on your case? And the court finds the admission freely and voluntarily entered. Court accepts it. We'll modify the probation to 1 year community control. Is that 1 year and 1 year probation
Yes, Your Honor.
concurrent?
No, it would be consecutive, 1 year of community control and 1 year of probation.
Okay, 1 year community control, followed by 1 year of regular probation. $100 cost of prosecution, $100 PD fee, $50 app fee, waive cost of supervision, complete ECLC or do a substance abuse evaluation, and complete any counseling. Adjudicated guilty. Is that it?
Yes, Your Honor.
Okay, thank you.
And the old one was revoked and we started over, is that correct?
Yes.
Thank you, Your Honor.
The old probation is revoked and it's a new term.
Your Honor, this is Colton Riggs. He's before the court on 24 CF 499. He's charged with violation of probation, currently has no bond. He's asking the court to consider a signature bond or any type of reasonable low bond. Mr. Riggs lives with his grandmother. He would be able to go back to work for his grandmother, and he's asking the court to grant him a bond.
What does the state say?
Your Honor, he has a new law violation with drug possession with intent to sell, manufacture, deliver, and then he was out on probation. He doesn't have a bond, I'm sorry, on the VOP?
Correct. He's asking for a bond on the VOP.
He's facing minimum mandatory on the new law because he's charged with within 1,000 feet from a park. I would ask that he be held without bond on the VOP because he's not entitled to it, and the
Was he
evidence that
out- Was he out on bond when he picked up the new charge?
he was on probation when he picked up the new charges.
What kind of minimum mandatory is he looking at?
I believe it's 3 years.
And Your Honor, I'll be filing a motion to dismiss, a B motion. There's a corpus delicti issue. They're basing that entire charge based on a statement he said while he was impaired. There's no evidence of any kind that's been produced to suggest anything other than his statement that what he said, that he was trying to sell his possession because he was homeless. And he's not even homeless. He lives with his grandmother. He was high and he was talking. So that's the whole, in the corpus, that's the whole
Y'all,
issue.
I'm gonna deny the bond at this time and just we'll see if you can work it out and work out a plea or dismiss or whatever. Since he's facing a minimum mandatory, yeah. Okay, thank you.
So I'll file the motion, okay?
Robbins.
That's okay. Your Honor, did you have an opportunity to review the report?
Mr. Robbins?
The state has had an opportunity to review Dr. Zeman's report. He opines Mr. Robbins not competent and recommends Florida State Hospital for competency restoration.
Is he here, Mr. Robbins? Are we?
He is, Your Honor.
Well, yeah, he's not competent to proceed based on Dr. It was, wasn't it Siemens?
Dr. Zeman.
Yeah, that's what I remember.
Your Honor, I did speak with my client about it.
All right, we're going to send him to hospital and get some help and see what we can do, okay? Thank you. Send me an order on that.
Rogers?
Your Honor, this is Sunny Rogers. She's before the court. The state did make an offer for a DPA. And I believe Ms. Rogers does want to sign those DPAs, correct? So there's also one for your misdemeanor. Are you aware of that? All right, so they're both here. So if you want to sign them so the court can go forward and release you. And Your Honor, she's signing it right now.
This one goes with this.
Yep, you're gonna have to sign it there too. And Your Honor, I was handed another one from County Court, Judge Ward, where the same thing has been done, where they've offered DPA in that as well. So that would be for case number 24 CF 1846 with Ms. Basso. And then there's 24 MM 4040, 24 CT 2673. We just need to give these to the DPAs. So can we just turn those to court?
Yeah. Do I need to take a plea on this or just?
No, Your Honor, because they're DPAs.
All right, Ms. Rogers, make sure you do these things, this agreement, then the charges will be dropped, okay? Okay. Okay, what's next?
That's it. You're good.
Salas?
Your Honor, this is Charles Salas. He's before the court for violation of probation. We're going to enter a denial. My understanding is that the state has filed a motion to transfer this case back down south. I don't know if Your Honor has signed it yet or not.
All right. It'll be transferred to a southern courthouse we have, and then a different judge. Okay? Thank you.
Violet?
Your Honor, this is Jeffrey Smiley. He's before the court on violation of probation on 24 CF 2123. He also has a, huh? Yes. Yep, we're going to do them right now. He also has arraignment this afternoon on 24 CF 2498, introduction of contraband into the detention facility. I'm going to enter a denial on the violation of probation on the introduction of contraband, not guilty, request trial by jury to be put on the pretrial docket. See you. They're off.
Is he going to enter a plea?
Not guilty, denial
Okay.
and then not guilty.
All right. We'll set him for January. What? 12:30. Thank you.
It'll be December 30th. Okay? I'm sorry? Correct. You'll stay in jail.
Okay.
Your Honor, this is Nicole Smith. She's before the court on 22 CF 2049, 22 CF 2626, 23 CF 1047. They're violations of probation. She has no bond. Ms. Smith has a broken hip. After she got her broken hip, she tried to get insurance, and once she got her insurance, she tried to schedule a surgery, and she has an appointment scheduled with the specialist for December 19th. It took 6 months to get it. She's a longtime resident of the area. She's always resided at the same address. Her paramour is present here in court. She knows that she is going to go to prison, you know, that she scores prison, and that will be the eventual outcome. She just wants the opportunity to get that appointment done, get her surgery before she goes.
Who is her appointment with?
His name is Dr. Smith. He's in Pensacola.
What does the state say?
Your Honor, she's an absconder. The violation, the warrant was issued over a year ago. She absconded all this time. She was out on probation on 3 cases. She was supposed to complete inpatient treatment but didn't show up, and the probation officer made several attempts to locate her everywhere, and they couldn't find her. She knew she was on probation. She decided to hide. I haven't been provided any medical documentation about the surgery that she has. She's facing a maximum of 30 years and a minimum of 26 months DOC. Now, I would agree to a furlough for the surgery, if that's what it is, or she can enter a plea to the guideline sentence and then set it for sentencing imposition at a later date. Those are my alternatives, I guess.
Well, hang on just a second, because both of y'all were talking at the same time, so I couldn't hear it all. You would agree to a furlough?
I would agree to a furlough for her going on the 19th to do, obviously she needs to provide the documentation and
Yeah, she can provide documentation. She can go to the doctor's appointment.
So, Your Honor, she did want to address two things. Go ahead.
Yeah, a couple of things, yeah. So I didn't hide when I left Keaton. When I left Keaton because during that time, if I hadn't left Keaton, I would probably be dead right now, honestly. Because at that time, I don't know what was going on there, but there were 6 ODs that had to leave by ambulance within a week. I actually had to revive one of the other clients there. And it is definitely not a therapeutic environment. Now, I understand that I have to pay the piper for leaving Keaton. I understand that. But when I left Keaton, I didn't plan on breaking my hip. That wasn't part of, and also when I left Keaton, I went to the address that they had on file, Okaloosa County has on file, everybody has on file. So I didn't run, I left and went to my house. So I don't feel like I hid from anybody. And sir, is my hip, if I don't get this taken care of, I'm gonna be a cripple.
Well, I'm gonna let you go on to your doctor's appointment, get some documentation, show your attorney and the state attorney, and you can go on a furlough to the appointment.
So my appointment, so you know, is with a general practitioner, and then he's gonna have to refer me to an orthopedic surgeon.
Well, get that documentation, and you can have a furlough to go to the doctor, come back to jail, and then go to your orthopedic person, get that done, and come back. Okay? Thank you. Okay. Okay, well, I'm gonna let her go to a furlough to see her doctor, but she gotta come back after the appointment. All right, thank you. When is your appointment supposedly?
The 19th?
Well, you better get the documentation so that the state can, I can't do it without the documentation for the state. A what? No, I'm not here to sentence her
He's
today.
gonna let you out to go. You just
I'm
have
not
to
gonna
get
sentence her.
proof
I don't
that
know
you got
anything
the
about
proof. That's
her
all
to
we
give her a
say.
fair sentence. And you're not her attorney, so have a seat.
then-
Thank you.
And then after you've done the appointment, then you go back to jail.
Okay.
Okay?
Okay.
That works.
These are all VOPs, so should put on a miscellaneous, I guess.
Yeah,
and
January 30th, I guess.
That's fine, Your Honor.
1:30, okay.
1:30? Oh, 1:30. Yeah.
Your Honor, this is Seth Talbot before the court on 20 CF 2428, 21 CF 2077, 23 CF 38. Your Honor, he has a new law. We're going to ask that these VOPs track the new law. And we're going to enter denial.
All right, what date do you want? January 30th?
Well, the next pre-trial, I would say, whenever that is, I'm sorry, Your Honor, I don't know the date.
December 30th or?
No, the following one.
February 24th?
That's fine.
Okay.
Is that okay, Ms. Rivers?
Yep, 224. That's fine, Your Honor. Yep. Mhm. Your Honor, this is Robert Vorpal. The state attorney had made an offer this morning that I need to convey to him. The jail had just not brought him over. He's here for a bond reduction. I would ask if we could put him on this afternoon's docket and allow me to convey the state's offer, because it is a one-day offer.
All right, we'll bring you back this afternoon and see if you want to take this offer.
Mm-hmm. Mm-hmm. Yeah. So if we could put him in an interview room for, yep.
Williams.
Hi, Mr. Williams. Your Honor, this is Isaac Williams. He's before the court on 24 CF 2216. Your Honor, I did have a competency evaluation done, and I did submit a copy of it to the court.
Yeah,
Your Honor, based on that.
he's not competent, if I recall, right?
Yes, Your Honor.
Well, send me an order, find him not competent to the hospital until his competency is restored.
The state will stipulate to that, Judge.
Okay. We're going to send you to the hospital to see if we can get you some help, okay? Thank you, sir. Good luck to you.
Willis.
Your Honor, we're going to enter a denial on Mr. Willis. I believe his new law is currently set for trial. I was just asking the state which she would like to do first, the VOP or the trial, or do them at the same time, which she preferred to do.
Could we set it for the 30th for a VOP evidentiary, January 30th? Well,
Let's get it January 30th.
except I don't know Judge Oberlis now if he wants us to communicate with the JA to set those contested hearings or not. I don't know. Should we set it just for status in the beginning of January, and then we ask Judge how to do
All
it?
right, January 9th.
Thank you, thank you.
So January 9th, you're going to address the status of your VOP, okay, with a new judge. Your new law is still set for trial, okay? Well, you'll come back December 30th.
All right.
Yeah.
Excuse me? Oh, okay.
Judge, Ms. Hicks is going to be a plea.
While we're waiting on that, Judge, I actually have Mr. Daniel Arnn, who's on the arraignment docket this afternoon, present. Mr. Arney. Mr. Arney is present, Judge, in 24 CF 2393. Judge, we'll enter a plea of not guilty. We want to get the FDLE report on this, so we still need discovery.
He's charged with what?
He's charged with possession of controlled substance, Judge.
All right, you pled not guilty, was set you for, what about December 30th?
That's fine, Judge.
Okay, thank you, sir.
Thank you, Judge.
I don't think they put in a request.
No.
Ms. Hicks, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes.
Okay.
Judge, I believe the score sheet's for.
You want to enter a no contest plea to the charge of felony, petty theft, a third-degree felony, and trespass, a second-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Count one, you're judged guilty, 6 months county jail with credit for time served. No trespassing at Walmart. Standard court cost of prosecution, and PD fees. Count two, you're judged guilty and sentenced to time served. Both cases are to run concurrent with each other. And adjudicated guilty on both cases.
Thank you, Judge.
Okay, thank you.
All right.
Tell me that Cochran's on property. Maybe get him in as soon as we can.
Yeah.
Ollie?
Ms. Turner, I sent over a counter offer of $11.29 on it.
For Christy Holly?
Yes.
Ms. Holly has a 30-month suspended sentence, so the state's position is to lift the suspension and.
All right, so Ms. Holly, they're not going to accept your counter offer, all right? Their position is on the VOPs, lift the suspension, so you would have 30-month state prison, and then we get credit for any time that you have served on. Judge can do is you can plead straight up and ask the judge to do including a lot more than the 30 months. So, Judge, I'm just going to move to continuance since we don't have a negotiated plea.
All right, we'll set her for December 30th.
Thank you, Judge.
Thank you.
I had talked to you last time.
Your Honor, just so she can hear me say this, we worked tirelessly with her. We really did. We tried everything in the book to help her. She wouldn't do it. She has a 30-month suspended. We kept telling her, hey, you got a 30-month suspended sentence. You better tighten up. Here we are.
All right, December 30th.
Thank you, Judge. And I'll explain why it's not as simple as you just telling the judge what you want, okay?
Yes, sir. Thank you.
Early?
All right, Destiny Hurley.
Okay. The state has agreed to that, Ms. Okay, what we discussed yesterday. So need to get your signature up here. No, ma'am. What it means is that your case is going to be over with. You're going to be reinstated to probation, so you won't need to post any bail. Oh, on your other charge, yes. Okay. That's all right. I'll date it for you. Judge, this is one of the state accepted.
Ms. Hurley, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God. Okay.
Oh, do you want an indication on it? She was originally with him. Okay, then just indicate that you want it. I just didn't have an answer. Felon now. You understand that? All right, Judge.
You want to admit that you violated probation, Ms. Hurley? You have to say out loud.
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudicates you guilty. Court's going to reinstate probation with the original terms and conditions, plus no alcohol, no establishments where the primary business is the sale and dispensing of alcoholic beverages. Complete mental health evaluation within 30 days. Take all prescriptions as prescribed. $100 cost prosecution on each case. $150 total PD fees, and that's it. Okay.
Thank you, Judge. Yeah, you're going to talk with them real quick.
And we'll request the probation fees be remain waived, Your Honor.
Yes, sir.
Judge, this is Susan Igus. She's here for sentencing. She's previously entered a plea. I have some documentation I want to provide the court. We had her evaluated for mitigation purposes. We'd had her evaluated. I've provided the court with a copy of the evaluation. Judge, also, I've got, does the documentation you have, does that include the acceptance from Saving Grace Women's Home?
Yes.
Okay, good. She also has been accepted to Keaton, is my understanding. And so what we're asking the court to do is to either sentence her to this Savings Grace Women's Home or to the Keaton program as an alternative to the sentence that the state's going to seek. This is a situation where she worked under another person's license. We provided evidence to the state that the other person, contrary to what they were claiming, was actually aware of it, but it doesn't deal with the primary issue that she's, to the limited extent that a nurse's aide does provide care, she was providing care without a license to do so.
What does the state say?
Judge, the state is asking for a minimum guideline sentence of 39 months, Department of Corrections. That score sheet was provided to the court at the entry of her plea last month. The maximum she faces to these 6 counts is 26 years. And the state would note that Ms. Igus has a prior record of similar conduct. In fact, crimes against the same victim, and there are multiple victims here.
Yeah.
In 2018, in Escambia, Ms. Igus was sent to prison for exploiting an elderly person for grand theft and 3 counts of uttering forged instruments. She got out of prison and
committed another crime in 2021 in Santa Rosa County, and that was using or possessing another person's ID. That's the same victim, individual victim that we have in this case, the nursing license of her former roommate. And she was sentenced to jail in that case. That disposition was in 2022, and she got out, and we come to the present case. This is a 6-count information that she's pled to. Practicing without a license in the field of healthcare is a very serious crime. The victims of that crime are the patients themselves primarily, because they think they're getting licensed care and they're not. But also the nursing board is being defrauded in that instance. Count 2, using false ID for workers' compensation claims. She provided a forged statement to workers' comp claim in somebody else's name, committing further fraudulent acts. Count 3, illegal use of personal information. She provided a birth certificate, the nursing license, and other certificates signed in the victim's name, the individual victim, her former roommate. Count 4, organized fraud. She, again, victimized Miss Finch, her former roommate, in count 4. Count 5, uttering a forged instrument. She signed documents at the Crestview Rehabilitation Center that were false in order to become employed, knowing that they were false. That victimizes our community, not just the Crestview Rehab Center, but all the patients there who trust that that center is going to give them licensed health care. And finally, the 6th count is false information to law enforcement officer. She told the law enforcement officer that that the victim was being paid for this. Now, what the state finds also troubling is that in Dr. Zeman's report, so to be clear, the state's position is that there's no basis for a downward departure. The downward departure needs to be both qualified as a valid downward departure basis and also appropriate, and the state doesn't believe that there's either here. In Dr. Zeman's report, the state would note that she seemingly contests these charges even in her meeting with Dr. Zeman. She continues to blame the victim even though she's the one that has continually broken the law and been in trouble for it. She also told Dr. Zeman that her 18-month prison sentence was for writing bad checks, and that's not true. And that is the problem, Judge. Dr. Zeman's report is not legally sufficient for a downward departure. It is based on a clinical interview with Ms. Igus that lasted 45 minutes in the jail. He reviewed jail records, which do not contain licensed psychologist reports, the referral from the public defender, and the arrest reports, the legal documents. There's nothing in here that is the basis. There's no diagnosis in here that is the basis of qualified information that is not directly from Ms. Igus. And that's the problem when you have somebody who has a history of fraud, is that they are not believable. There is no credibility for her. So for those reasons, the state is asking for the minimum presumptive lawful sentence, which is actually 38.175 months, Department of Corrections.
Your Honor, if I can respond briefly. With regard to Ms. Finch's involvement, we provided discovery evidence that suggests that Ms. Finch is not being truthful when she says that she was not paid. The gravamen of the offense, though, is that she's still using Mrs. Finch's information and using a license that she doesn't have. Now, with regard, though, to the danger to the community, one, I'll point out that nurses' aides actually have very limited abilities in terms of the care that they're allowed to render. but I'll point out on page 4 of the incident report, it says, I then spoke to Finch. She advised she initially found out about someone working under her name at Crestview, and this was actually the second time. And the first time, Ms. Finch, I want to say admittedly knew that this was going on. Due to the center mailing out a card thanking Finch for her hard work. That was work performed by Ms. Igus. So she was not in trouble for rendering bad patient care. She, in fact, was being lauded by the facility for the work, but because she was using Ms. Finch's name, the card went to Ms. Finch. And that's how Ms. Finch found out about this occasion. So, Judge, considering the issues that are raised in the psychologist's report, I am asking the court for a downward departure.
All right, well, she just got out of prison for fraud or writing bad checks, and then she turned around and did this, correct?
Judge, I'm not in a position to.
All right, 48 months Department of Corrections concurrent on each case, and a misdemeanor 11 months, 29 days concurrent. Credit for time served. Thank you.
You said 38, Judge? Or
48.
48.
Oh, my God.
Okay.
All right, good luck to you, ma'am.
All right, ma'am.
And I believe we have Cochran available here.
Cochran?
Oh, wait, I don't have my paperwork. Ms. Flowers said we can wait a few minutes.
Okay, so we'll have to wait a little bit. Do that Horn?
Judge, I had advised the court last time in court that I was filing a motion to suppress. I have done that, and I provided it to the defendant, but I don't believe there's been sufficient time for the state to get out subpoenas, and it looks like there's going to have to be witness testimony on this. And Mr. Horn, I mailed a copy to you, so it'll probably, if you haven't gotten it yet, it'll be at the jail probably when you get back.
Mr. Williams, I apologize. Who's this defendant?
Joseph Charles Horn.
Okay, it's my case. That's what
I
I'm
don't think the state's going to be prepared to proceed today, and it's going
No,
to be.
sir, you filed it yesterday, so it's really unreasonable to even think.
What about January 9th?
That'd be great.
Okay. January 9th.
January 9th? All right, Judge. All right, so you'll come back in on the 9th. I'll go ahead and give you another copy of it. And, Judge, it needs to be set on the afternoon docket, I think, because there'll need to be witnesses. Thank you.
Again,
All right,
that's going to be with Judge Oberlis, and I don't know how he wants to do it.
It's not scheduled for a bond hearing.
We said it, and he'll adjust it to however he wants.
How about this, Your Honor? Mr. Williams, this is a new case. How about we set it for December 30th, pre-trial? We ask Judge Oberlisen how he wants to hear those motions to suppress, if he wants them in the afternoon, if he wants them in the morning. I don't know that.
Oh, on that, I don't, yeah, if, since it'll be Judge Overleeson, then just whenever he wants to set it for, is fine with me.
So should we set it for those purposes for the 30th, December, because it's
Well,
pre-trial?
he's coming in on the 30th anyway for pre-trial.
Right. So we set the case for pre-trial. We ask the Judge Oberlisen how he wants to handle the motion to suppress.
That's fine.
Okay, thank you, Judge.
All right, very good, December 30th.
And I'll go ahead and, I'll draft up a bond motion for you. We'll have it heard on the same day, okay? Obviously, if you win the motion of suppression, you won't need the bond hearing.
What day am I coming back, sir?
Or December 30th, okay? And then possibly January 9th as well, but you'll definitely be here on the 30th.
Johnson.
Thank you, Your Honor.
All right, no problem. Is this David Johnson?
Yes, sir.
All right, Judge, Mr. Johnson is actually set today, I want to say I've got him for an arraignment. So we can go ahead and arraign him, Judge. I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
Is this a arraignment on a VOP?
Yeah, he's got a VOP that's scheduled for this morning, then he's got a new charge for
What's
this
the new
afternoon.
charge? I don't have my afternoon docket. What's the new charge?
The new charge is a false imprisonment and domestic violence battery. The state filed back on November 14th.
All right, that's what you're charged with, Mr. Johnson. I'll appoint the public defender to represent you and bring you back on what day y'all want, December 30th? December 30th, okay?
All right, Judge.
Thank you.
Yeah, I'll come back out and see you again before the 30th. All right, excuse me just a second. Is this Bo or is Joshua Bo or is this? Okay. Judge, I'm going to enter a denial for today's purposes. I think ultimately I may have to depose the probation officer.
All right, this is, what's the day up for our VOP? January 30th? Set for January 30th, okay?
Thank you, Judge. Okay, Mr. Johnson.
Jordan.
Jordan.
Ms. Turner, I'd sent over I think you were asking for 180, and I sent over a counter offer for 120.
Is this his sole, this is a technical violation?
Let me see here.
High time. Losing my voice.
Changing residence, favor record.
Yeah, today we can do that.
Okay. Judge, we've got a negotiated plea in this case. Second.
Is this Mr. Jordan? All right, Mr. Jordan? Yes. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
This
There we go. All right, let me get your signature
one,
up
that's
there.
180 for okay.
That's 120.
120 for okay at the time, sir.
Yes. No one has to announce credit for time served, sir. You have to specifically waive it in order to not get it.
Okay.
Okay, it's automatic.
Okay.
Idea what's good.
All right, Mr. Jordan, you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this admission?
Yes.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing?
No, sir.
Are you happy with the work Mr. Williams did for you?
Yes, I am.
Court finds the admission freely and voluntarily entered. Court accepts it. Revoke and terminate. Judge guilty, sentenced to 120 days county jail with credit for time served. All outstanding monetaries to collections. Okay, adjudicated guilty. Thank you.
Thank you, sir.
Thank you, Judge.
Have a good day.
Good luck, sir.
All right, this is Kevin Judy.
Judge, I actually got a chance to look at it yesterday. I received it the day before. Documentation showing his date of hold, so the credit's going to be a bit longer. But I don't think I have a specific offer. Probation, I think, was recommending 18 points, and I scored him out at 15.5.
18 months.
Or that's what I said, 18 months. I'm sorry, that's what I meant. I scored him out at 15.5 months. What's your offer, ma'am?
It's 18.
18?
18 months.
All right. Sir. Well, you get credit for all that. Yeah.
Credit for time served.
Credit for time served, whatever that is, okay, including the time you were waiting in the other facility in Mississippi, I guess it was.
In Georgia.
Sir, if you have to think about it, that's fine, but I'll ask him to bring you back this afternoon.
Okay.
Okay? Bring him back this afternoon, if you don't mind.
All right, thank you.
So, Judge, I'm going to ask to pass him.
All right, you want to go January 9th?
That's fine, Judge.
Okay, thank you.
All right. I'll see you before the night. I'll come out. Judge, Ms. Lawson's before the court for a bond motion. She did ask to speak with me earlier today. She's asking me to add both case numbers to this motion, so I'll orally amend the motion to add both cases to it. She also asked me to, or advised me that she just had a grandchild towards the end of November, and so I'll add that as additional reasons why she would remain in the community and be available to attend court. And I'll amend the motion not to just ask reinstatement of the original bond, but to ask for a signature bond to cover all.
What's her current bond?
Right now, I believe the bond on the old charge was revoked as a result of a new charge.
What was the old charge?
Judge, the old charge was introduction of contraband, or possession of a controlled substance, driving on a license suspended as a habitual traffic offender, and possession of paraphernalia. So 2 third-degree felonies and 1 second-degree misdemeanor and 1 first-degree misdemeanor.
What's her new charge?
The new charge, Judge, is she disputes, and in fact, she's here for arraignment on it. It's a grand theft and deals with the theft of a cell phone. It was the incident that was in court when we were in court last time.
I'll point you to represent her on that.
Yes, sir.
And her current bond is no bond.
Her original bond was revoked as a result of the new case. And so it's no bond on the old case, Judge.
The state objects to any modification to Ms. Lawson's bond. She was here in this courtroom on October 28th, and she is on the cameras stealing another witness's phone out of that pew right there. And we've shared that discovery with the defense. Sergeant, I think Jenks gave it to us. I've watched it, and we're going forward on that because that is very...
So she was here on some case, and it's alleged she stole someone's phone?
She was here on the introduction of contraband to the jail and the possession, the driving charge, and the paraphernalia.
I want to leave the bonds the way they are.
Committed a crime in this courtroom, Judge.
Allegation she committed a crime while she's here?
Right in front of the court.
I'm going to leave the bonds the way they are.
Yes.
Thank you. Thank you.
That's it. Yeah. Oh, Judge, I still need to arraign her on the new case.
Yeah.
You appointed me, plea of not guilty, 15 days pre-arraignment motions, trial by jury.
All right, December 30th.
Thank you, Judge.
Thank you. All right, Andrew Madiak.
Judge, this is going to be a negotiated plea.
I don't have a negotiated plea with this.
At some point, you asked 4 years on all felonies.
Oh, you want to take that?
Count 3, the
Oh, yeah,
mandatory
we have.
minimum.
I thought he wanted the probation. I said, we don't have that.
Well, I know, but you've got him charged with a charge
That's
that
fine.
carries a mandatory minimum, so unless you're likely to change your mind on that, and we'd love it if you did, but otherwise,
Sounds good. Thank you, Chief.
Mr. Madiak, would you please raise your right hand to be sworn? You swear the testimony you give for his court's true, so help you God?
Yes, Your Honor.
Okay.
there's the agreement, Judge.
You want to enter a no contest plea to the charge of fleeing, attempting to elude at high speed, a second-degree felony, possession of a false driver's license, third-degree felony, aggravated assault on a law enforcement officer, a second-degree felony, with a minimum mandatory 3 years in prison, reckless driving with property damage, first-degree misdemeanor, resisting arrest without violence, first-degree misdemeanor, criminal mischief more than $200, less than $1,000, first-degree misdemeanor. You want to enter a no contest plea to all those charges? Okay. Did you read and sign this plea and sentencing agreement form? Are you aware you did? You have to answer out loud.
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you
No, Your
from?
Honor.
Are you happy with the work Mr. Williams did for you on your case? You are? All right, the court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty, sentenced to 4 years on all felonies. On count 3, the first 3 years is a minimum mandatory minimum with credit for time served. 11 months, 29 days county jail. You're sentenced, first of all, you're judge guilty, sentenced to 4 years Department of Corrections on all the felonies concurrent with each other with a minimum mandatory 3 years on count 3, minimum mandatory 3 years in prison. You're sentenced to 11 months, 29 days on the misdemeanors, concurrent, all cases, all counts running concurrent, 2-year driver license suspension, reserve on restitution for 90 days, standard court costs, cost of prosecution, and PD fees. Judge guilty on all case counts.
Thank you, Judge. All right, good luck to you, Mr. Mattiak.
Mr. Jason McDonald.
Judge, I received some information about Mr. McDonald's case from the state. I've been trying to go back and see him, but he wasn't brought over until after my cases had started, apparently. I'd like, actually, just give me a minute.
About to dive here with us.
Judge, my understanding is the state is going to want to personally review the evidence that they told me about this morning. And so it looks like we're going to need to pass his motion. And I need to speak with him about it as well.
So you want to go to what, December 30th?
Well, do you want to hear a motion hearing on the 30th?
About January 9th?
I'm going to say January 9th to play it safe. He'll be in on the 30th. We may be able to get it all resolved by then.
All right, January 9th.
Thank you, Judge. All right. So I'll come out and I'll tell you what's going on, okay? They'll send me a copy of it and we'll be.
Yeah, he's pleading not guilty, 15 days for motions, trial by jury.
That's correct, Judge.
I got it memorized, almost. All right, Martin McDonald.
The recommendation, the offer is 6 months.
I believe, yes, ma'am, 6 months.
I mean, I'm not inclined to do too much negotiating. He accepted the probation in August 26th and was arrested October 2nd. I'd stick with the 6 months. I mean, he didn't do much.
He's asked me to change the counteroffer to 5.5 months.
No, we're not going to do those kind of games.
Yes.
6 months is what the offer.
Sir, do you want to take the 6 months, or do you want to fight it out?
Credit for all time served?
Yes, everybody gets credit for all time served unless they specifically waive it.
Okay.
All right, sir, let me get your signature on it then. Right there.
I like the price is right.
Now, what about the other case? Time served on their end.
Oh, Judge, did you get an authorization from Judge Ward to handle his misdemeanor case? I believe it's a trespass. I talked with...
I think Mr. Gibbs got me something from Judge Ward saying that he doesn't care if we wrap these misdemeanors up, is my understanding, right, Mr. Gibbs?
That's my understanding as well, Your Honor.
I think Judge Ward doesn't care about that.
He's inclined to plea to that case. I sent an email over to his public defender on that case who said that that was correct, but I also sent an email over to the state.
All right, hang on a second. Is that's not a lesser included or something, or
No,
not additional? Nope. Plead in front of Judge Ward.
All right, Judge.
If it was attached to this case some way or another, yeah, but.
No, sir, it's not pendant jurisdiction.
No, I don't want to. Judge Ward, he needs to, he wants to handle his separate docket.
What I will do, sir, is I'll ask Mr. Hall to get you in front of Judge Ward at the earliest opportunity. But that's all I can do. I can't force the judge to take a plea for another judge. Sir, you need to stick around for the judge to actually say.
This is Martin McDonald.
That's correct, Judge.
Mr. McDonald, would you please raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Did you read and sign this probation plea agreement?
Yes, sir.
You wear the rights you're waiving by you can put your hand down. You wear the rights you're waiving by entering this admission?
Yes, sir.
Anyone would force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds admission freely and voluntarily in. Court accepts it, adjudicates you guilty, revoke and terminate. Sentence you to 6 months county jail with credit for time served, $100 cost of prosecution on each case, $150 on each case, on just this case, $150 total PD fees, and that's it. Thank you.
And that's the same offer that was previously given to me and that I reviewed.
Okay.
The outstanding monies to collection, Jeremy.
Yes, sir.
All right, sir.
Dwayne Moore's in other institutions.
Yes, Judge. Mr. Moore is, I believe, here on a competency review, but I've not seen any
bring him?
report from the agency.
Okay. I don't remember seeing that either. Hadn't he been in front of me on this several times?
I'm sure he has, Judge. Typically, what we do under this circumstance is we pass it out for about a month, and then somebody gets a hold of the facility.
All right, well, we'll do that then, I guess. And
All right, Judge.
January 9th, how about that?
That's fine with me, Judge.
Morrow?
All right.
Judge, Mr. Morrow is here on remand from the District Court of Appeal to be allowed to withdraw his plea. He has filed a pro se bond motion, which I will now adopt, and I believe that the state's prepared to go ahead and argue both, and that they're not disputing the change of plea. So basically,
He wants to withdraw his.
not change of plea, withdrawal of plea. So we need to set him back on the trial docket, and then the court needs to address the bond situation.
All right. So, Mr. Morrow, you want to withdraw your plea? Is that correct, sir?
It is, but I actually want to speak to you if I could prior to.
Well, I can't advise you on what to do in any way. Apparently, the appellate court says you can withdraw your plea, I believe. You want to withdraw your plea?
Yes, sir, I do.
All right. The court will allow him to withdraw his plea and put him on the trial docket. We'll set him for pretrial on February 24th. Is that the correct date?
I believe that's fine, Judge. That's a date that you gave earlier on other cases being set on the trial docket.
All right. Now, you want to talk to me about a bond?
Actually, I want to move forward with discharging my counsel. I believe that I may be, this is going to be new to him, but I do believe I might be in a conflict with him as well. The first time meeting the man, he did tell me that my prior attorney, who I was in a conflict with, that he had some sort of friendship relationship with, and I believe the issues regarding my violation of probation charge and this new case, Randy Etheridge had represented me on both cases, and I feel that there's just going to be a conflict between me and him because I don't believe that our views are going to line up. I'm going to move to dismiss both cases on two completely different issues after the withdrawal of the plea. And I'm basically claiming that Randy Etheridge was ineffective on my 2017 case, and there was a manifest of injustice, as well as ineffective on this case, and I just feel that I'm not being adequately represented by this council.
Was Mr. Etheridge in the public defender's office at the time?
No, sir, he was not.
But you say Mr. Williams has a conflict because,
Judge, Randy and I are friends. We've been friends probably since around the mid-1980s.
oh, and so part of Mr. Morrow's allegation is that Mr. Etheridge was ineffective?
Right, that's how he was allowed to withdraw his plea. And I spoke to Mr. Morrow a little bit ago and told him some errors that I had found, and I by no means completed my review of it. But that I had found as well.
I mean, don't we need a formal Nelson hearing, or do you?
You would need either a formal Nelson hearing or a formal Ferretti hearing, because I'm also hearing him say that he wants to file.
Well, I'm not going to let him represent himself at this point, but it may get to that. I prefer to appoint another attorney if you feel that there is possibly some conflict of interest, Mr. Williams.
Judge, we're all professionals. We go up against each other all the time. Randy and I have tried cases against each other when he was a defense attorney and I was a prosecutor. I won one, he won one. His guy went to prison on mine. So I don't think there's any actual conflict, but I will say this. Mr. Morrow seems to feel that there was. He actually raised another ground with me. Do you want me to talk about my experience as a prosecutor?
I mean, I was more or less curious to see where you stood, why you moved from being a prosecutor to public defender.
Let me, I think because this came back as ineffective assistance.
Your Honor, if I may, it didn't come back as an ineffective assistance. Actually, a technicality, the court found that there might have been some animosity or some disagreement between counsel and the client. And the court did not, even though the court was aware of that, at the time of the entry of the plea and the sentencing, the court did not allow Mr. Morrow to withdraw the plea. But it wasn't because Mr. Etheridge was ineffective per se. It was because there was an appearance of a conflict so that he may not have been acting in the client's best interest.
What judge was that?
Your Honor, I believe it was up here, so I think it was Judge Ketchel, I believe.
Wasn't me, right?
No, Judge, it wasn't you.
Trying to
My
look and
recollection
see.
is
Let's
you
get
were
the
in
records
family at the time.
on the record. It wasn't Judge Gontera.
She is correct, it was Judge Ketchel.
Looking for my sentencing letter.
I tell you what, give me something in writing or here we also have the situation is, it's going to be another judge.
Yes, sir.
I'm not even going to be his judge to make this decision. So I would like, and probably Judge Oberlesen too, more clarification, Mr. Morrow, on what your situation is.
Yes, sir.
I'm sort of inclined to give you another attorney, but I really want to see exactly just because he's friends with Mr. Etheridge don't mean
No, sir.
that's
I
it.
understood.
But I understand you may have some other issue. Let's put it in writing and then, see, I'm not even going to be the judge next time in court. So that way, the next judge that comes, Judge Oberlesen, will have a record of what your actual allegations are. And he'll have a Nelson hearing and maybe let you have another attorney. I'm sort of would want to wait till I see in writing what it is that you say Mr. Williams cannot be effective for you, or there may be some conflict, okay?
Yes, sir.
I'm interested in what you're saying, but I'm not going to be your judge. I mean,
I understand.
So,
Yes, sir.
let's get it in writing and have a formal hearing where Judge Hoberlisa can look, actually see, okay, you got a problem, I'm gonna give you another attorney, or I don't. You don't, I'm gonna let you have Mr. Williams. And go at that point. And then if you want to do a Ferretta because you don't feel Mr. Williams is doing, that can be done at any time.
Yes, sir.
Okay.
It's not that I want to fret. I'm not trying to represent myself. I just feel that when the First District Court of Appeals mandated that I get conflict counsel, I believe that you actually had asked him last court date why the Public Defender's Office had picked it up and not regional conflict counsel. And then finding out what he had told me between him and Randy, and then my underlining issues regarding my cases in whole is where I feel that there may be a conflict between me and him.
I got you. I mean, I understand, I see what you're saying.
Yes, sir.
And Judge,
And I think it's an interesting legal situation. I mean, if it was me, I'd want to get it right.
yes, and Judge, I don't have a position either way on it. I'm fine with
But
whatever.
put it in
is
writing.
decided.
If I was still going to be the judge, I'd probably go ahead and do something, but I'm not going to be your judge on your case all the way through. So let's get something in writing for the record, okay?
Yes,
So
sir.
draft something up in writing, put everything in it, all
Yes, sir.
right? And then send it to the clerk. This clerk will send us a copy of it,
And then we'll have a
and we'll set a
Nelson-
hearing on it.
We'll
at
have
that time.
what's called a Nelson hearing,
Okay, yes, sir.
okay?
Yes, sir, I do appreciate you.
All right.
Okay, no problem.
Thank you.
All right.
We got yoga going on out here.
Judge, this is Christopher Murray. I've had Terry Henderson go out and meet with him. He'd inquired about drug court. She sent communications to me saying that she finds that he's a candidate for it. And in fact, I think you've been to one drug court proceeding. There'll be another couple that they take him to. So I'm just going to ask to continue it and let them figure out what they want to do on that.
All right, to win.
I know there's not drug court next week. Judge, I'm going to say give me something towards the end of January, just so that we're sure enough time has taken place.
All right. 30th.
Thank you, Judge. All right, now, drug court will take over if you decide to take it and they still want you, okay? Okay.
Is this yours? Is it? I don't know. Is yours? Yeah.
Ms. Turner?
Yes.
We had talked about considering Keaton in the case. If you don't want to do Keaton, he would Keaton has accepted him, or you still doing Keaton, so I'll draft it up.
I believe this is Miss Leone's case. I cannot speak intelligently
I've got
to
it as
it.
an F3 possession of a controlled substance.
Yeah, I have it for some reason. I had 1129 offer, jail. About 9 months.
Okay.
Take 9 months.
All right, Judge, hang on a second. I'll make a change here.
So he's entering a plea for 9 months?
That's correct, Judge. All right, let me get your... This is the same rights and everything. I've just changed it to 9 months. Okay. me get your signature right there. Yeah. Yeah, it's the same as I've got.
I'm sorry.
Okay, no, that's fine, that's fine. Yeah. Here, you go ahead and sign it, and then I'll scribble my thing. Because nobody expects to be able to read my handwriting. Sir, you mind if I date this for you? There you go, Judge. Yeah, you get credit for time served.
Mr. Nelson, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
All right, State of Florida versus Kenneth Nelson, 24 CF 2265. You want to enter a no contest plea to the charge of possession of controlled substance, third-degree felony. Is that correct?
Sir.
And you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams did for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentences you to 9 months county jail with credit for time served.
Thank you, Judge.
Okay?
All right, sir. Yeah.
Nichols.
Judge, we've got one case before us for arraignments. That's 24 CF 2528. I don't have a copy of information as yet. Madam Clerk, has the state filed? No? Okay.
We're here for a criminal possession of controlled substance without a prescription.
Judge, both of them are possession of controlled substances. He's also got a VOP. No. Not a VOP. Then why are you here in the morning?
No probation.
You weren't on probation?
No, sir.
Yes, we're doing VOPs. Judge, I don't know why he's here in the morning. One of the cases he's been arraigned on already, and it was set for today because he had the new case coming, I think. And so we were just going to keep them all together.
You need the information in 2528?
Yeah, 2528 is the one that he's here for arraignment on today.
I thought I had one prepared. I thought that it was filed. I can print it right now, just for the court.
What's he charged with?
Possession of controlled substance, 2 times.
Well,
Let's make sure.
they're the
One
one
is
filing the
possession of
information, so we
methamphetamine,
want
one
them
is
to.
possession of fentanyl, Judge.
One is possession of fentanyl, one is possession of meth, correct, Ms. Turner?
Right, the original case, Judge, is fentanyl, and then the one that she just printed out the information on, I don't.
Methamphetamine.
Right.
All right, I'll appoint the public defender. You gonna plead him not guilty?
That's correct, Judge.
How about, what you want, what date you want? December 30th?
December 30th with the holidays.
February 24th.
Thank you, Judge. If we can get him an agreement earlier, then we'll bring him in.
Okay.
Okay. All right, sir. Yeah.
Thank you, sir.
Thank you.
I think that's all I had for Mr. Williams.
We got Mr. Gibbs still to go?
Yes, Your Honor.
Judge, I believe also we had the 12:30 hearing with Ms. Flowers.
That's fine if you want to go ahead and do that.
Okay, let's do our detention hearings. I gotta go, I have to go get my paperwork real quick. So we'll take about a 5-10 minute break.
Thank you, Judge.
All rise, please.
Well, while we're doing that, let's see here.
1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Have you been injured in an accident and need righteous representation? Call us. We fight fire. Damn thing ain't working. Whoa. I'm gonna turn Coy Brownie.
That's on that.
Take a breath.
There's sentencing.
You have it? I was trying to see if he was out on bond. It's a young guy born in 2001. 50. The middle name is with Z. But let me take the case number and let me see if it's you. Well, it's your case, Jay. The original case when he was out on bond is your case. He picked up a new, right, and he picked up a new, it's trafficking in fentanyl.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview, or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
It's like going grocery shopping with kids or your spouse, and you're having a conversation.
Alex Clarke from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Brownie. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
It says victim would like case problem. Especially if they're super willing to be.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense
Felony,
attorney with Warrior
possession
Law.
felony,
I represent
and
those
felony
accused in Santa Rosa, Okaloosa, and Walton
So,
County.
probably
If
adjudicated.
you or anyone you know has been accused of the crime, give us a call.
I mean, it shouldn't make a difference to her.
Well, and I don't know if it would actually affect.
Now, yeah. What did I say, 30 days? Is that what I said? It's not very much, honestly. Might get more in misdemeanor court.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UP.
2690. Is the state seeking pretrial detention? What kind of bond are y'all looking for?
Judge, we're seeking a $150,000 cash professional bond. He is charged with sexual battery of a child under 12, which is a capital felony. Allegations involve the defendant, who is the victim's father, sexually abusing her when she was 10 to 11 in 2021 and the end of 2022 up in Crestview. Reported in Andalusia, which is where the victim lives with her mother, in 2023. We do have flight risk concerns in this case. He has a history of failing to appear in court. He does have an FTA from Alabama from 2019 and one from 2023 here in Florida. He does appear to be transient. When OCSO caught up with him in Bay County to ask him about this case, he did tell them he was homeless, and his address is actually a church in Panama City Beach, listed on David. My office spoke with the victim's guardian, and in accordance with Marcy's law, she wanted the court to know she wants the defendant to be held accountable, does not want him out of custody, and would like to see justice done in this case. Also has concerns for potential contact with other minors. Based on the serious nature of these allegations, the flight risk concerns, that's why we're asking for the $150,000 cash professional bond. We also ask for weekly in-person reporting on pretrial, GPS, no contact with the victim, and no contact with minors.
Your Honor, Jennifer Flowers with RCC for the defendant, Timothy Cochran. We're asking for a signature bond and or a lower, possibly $5,000 cash or professional bond. He does have a local address that he can stay at. His dad, his name is Bobby Carroll, and is local and lives in Crestview. I would point out that Mr. Cochran was cooperative and compliant in this investigation with law enforcement and being interviewed. He is stating to me that his last felony conviction was 15 years ago. He's denying these allegations adamantly. He would be amenable to and agreeable to the ankle monitor and would stay at that local address that we could provide the court today.
Is it just one count?
Yes, Judge.
Yes, Your Honor. He's saying that his intent is to try to post some sort of bond, but $150,000 cash professional would be equivalent to no bond for his circumstances, and that if he can get out, he wants to start working and build up some funds to defend himself.
He has 2 failure to appears, one out of Alabama, one out of Florida.
Yes, Judge.
Do you have years on those?
Alabama 2019 and 2023 for the Florida.
All right, $150,000 cash professional, GPS monitor, no contact with victim, pretrial services supervision. Thank you.
Thank you, Judge. I'll come see you as soon as I can.
All right, thank you. We got next, Sledge. Is it Sledge or Jones?
We always rotate the duty on these. So, yeah, I'm covering for Lisa on Sledge. It's my turn at bat.
It's 24 CF 2745, State versus Julius Sledge. What's he charged with?
Attempted premeditated murder and evidence tampering.
Are you seeking pretrial detention?
I did. I actually filed a motion for pretrial detention.
What's this defense say?
Judge, my understanding of the state's going to pass the case. I'm going to object to just them relying on the arrest reports. They need to get some witness in to testify to justify the pretrial detention. So my understanding is that they're going to continue the pretrial detention motion. The statute allows them to do that one time.
Well, the problem, Your Honor, is that the victim got shot and she's currently in the hospital. They thought she was not going to make it. Fortunately, she may make it, so she cannot be here. And the law enforcement wasn't available today because of the short notice.
Judge, hearsay is admissible, but it can't be based on the prosecutor just reading the arrest report into the record or something like that. So they can get the officer in eventually. Like I said, they're entitled to one-time
Why don't we just continue it till
continuance.
next Thursday?
That would be fine, Your Honor.
And then you can have an officer in if that's what you want to do.
Yeah, I just want to indicate to the court that I may still not have the victim here because she's hospitalized, and
Well, you can have the officer testify.
he would be objecting to the hearsay. That's the problem.
No, I think hearsay is admissible. What I'm going to have to object to is you just like reading the arrest report. And proceeding without some live witness to testify as to their knowledge, even if that includes knowledge that was provided by other people.
Okay, that's cool.
But talk with whoever's next at bat next week, and they'll be able to tell you.
What court, what's that court date?
Crazy.
Say.
All right, thank you.
All right, thank you, Judge. And so what's that date, Madam Clerk? 12th, thank you.
What's Mr. Jones charged with?
Mr. Jones is charged with several counts. 1 second, Your Honor. He was out on bond on 24 CF.
Oh, he's not out yet. Hang on 1 second.
No, I was just,
Which Jones?
it's just Robert.
Yeah, I've got a couple of Robert Jones's judge. I wasn't aware of the
Retrial
him
detention.
being added to the docket.
Right, this is Robert Zacchaeus Jones, correct?
Yes, sir. I have him on another case, but the state informed me just a few minutes ago that he's alleged to have committed another offense and is on the pretrial detention docket, was added to the docket today. Judge, I'm going to have to ask to pass it. It depends, I guess, on what the court does on the case that he's already got.
Yes, Your Honor. What I was going to ask the court and what I was stating is that he was out on bond on fleeing and eluding and driving while license suspended. Then he committed this other crime that was much more serious than the previous one, endangering the public. He's currently charged on the new case with reckless driving, fleeing and eluding at high speed, possession of cocaine, 2 counts, trafficking in fentanyl, 4 grams to 14, which carries that 7-year minimum. And I'm so sorry, I lost the page.
He was out on bond on those charges?
He was out on bond on fleeing and eluding, and he picked up those.
Oh, I'm not going to give him a bond then.
So is the court revoking the older bond?
Yeah, I'm going to revoke the older bond. So now what you want to do on this?
On this one, I was going to ask for reasonable bond on the fentanyl charge, 50,000 cash or professional, fleeing and eluding, 50,000 cash or professional. The rest can be signature bond.
Judge, we do have a bit of a wrinkle in it. I'm trying to bring up his case on my computer. He's just asked me if or indicating that the original offer was, in his old case, was, there it is, was 10 days. I'm showing actually, I guess one of them's going to be this current case. Let me see if I can bring that up and confirm that.
So how many counts has he got on this case?
On the new one, I'm pulling it up. It's got total of 12 counts.
12?
Yes, sir.
And what was the first, the 50,000 cash professional was on count 1?
According to benchmark, that would be count 5. Then the other 50,000 should be on count 2. And count 1, it can be 2,000 signature. Possession of cocaine, 2,000 signature. Count 4, 2,000 signature. Count 6 would be sell, manufacture, deliver. I would ask for 2,000 cash or professional.
I'm just going to make 2,000 signature on all the other.
On all the other counts, that's fine, Your Honor.
Count 2, 50,000 cash or professional. Count 5 50,000 cash professionals, 2,000 signature on the other counts.
Okay, that's fine. Your Honor.
And then revoke on the other case.
Thank you.
Judge, on the case that you just revoked, he just inquired of me if he could go ahead and accept the state's original offer on that case.
No, because it will be revoked, Mr. Williams, by him committing another more serious crime. He should have taken it.
So, all right, Judge. Is he currently have an arraignment date on the new case? Okay.
All right, thank
so
you.
I'll come out and talk with you before the 9th, all right? And, I'll answer any questions that you have then. All right.
All right, thank y'all.
Yes. Well, no, not on the original case. You have no bond on that right now, okay? All right, thank you, sir.
Right here for Your Honor, Tim Gibbs on behalf of Mr. Herbert Adkins. Judge, this is 07 CF 622. If we could approach.
Judy, is it my case? No, it's not.
Grab my pre-trial detention stuff. I didn't grab my afternoon docket. Damn it. All right, well, what?
UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open.
All right, we're going to arraign Mr. What was it, Adkins?
And it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be.
I don't even have my afternoon. I mean, just.
Page 11.
Okay, we have 499 cases to go, Mr. Gibbs. Come on.
Yes, Your Honor. Judge, if I could just reset Mr. Adkins then to January 9th.
All right, January 9th, Mr. Adkins. Thank you.
Able to resolve it today. I'll come see you in the jail, okay? Yeah. Yeah.
All right, Jake Coleman Bell, 24 CF 2560.
Yes, Your Honor. Tim Gibbs on behalf of Mr. Bell. Judge, we are here for a motion to reduce Mr. Bell's bond.
What's his current bond?
Your Honor, his current bond is, I believe, $3,000 cash professional total. He's got one charge, $2,500 for attempted burglary, $500 for loitering or prowling. He is unable to make that bond. The allegations in this case, Judge, indicate that he was pulling on car door handles at the Ford dealership in the south end of town. We haven't received an offer from the state yet. They are still working on that. The court would actually probably be able to notice from the arrest report that Mr. Bell actually allegedly stated post Miranda that he was looking for money to buy food. He is homeless, although he does have a job waiting for him at Taco Bell if he is released. He would be seeking services at the shelter in town on Duggan Avenue. He's otherwise been in the area for 10 years. He does have a previous failure to appear from 2018. Believe what happened there was he was trying to get the bus from, I believe, from Crestview to Fort Walton or Fort Walton to Crestview. There's only one bus that runs between those two, and so that's why that FTA occurred. Judge, we're asking for these bonds to be modified to an ROR signature bond.
What does the state say?
Mr. Gibbs, this is just on 24 CF 2560?
Correct.
Why wasn't he given a bond?
He has a total of $3,000 cash professional bond,
I'm fine.
and then we're asking for a signature bond.
That's fine, Your Honor.
Okay.
All right, 3,000 signature bond.
Thank you, Judge. All right. So you're already set for December 30th. Call me to set an appointment after you get out, okay?
Okay, yeah.
All right, December 30th.
Thank you. Oh, he's not. I'm sorry.
When is he set for?
He has a new law, so he not
Yes, Jake Bell. Yeah. So we'll ensure not guilty plea.
All right, February
24th.
24th.
Okay. Call me after you get out to set an appointment.
Yes, sir. Thanks so much.
Your Honor, Tim Gibbs on behalf of Mr. Coleman Blocker, 24 CF 244. Believe we have an agreement.
Mr. Blocker, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir. So they're going to revoke and terminate, put you on a new term of 2 years probation to do Phoenix House. So that's what you want to do. So grab the pen. Right there for me, please. And then today's date. I may approach.
You want to admit that you violated probation, Mr. Blocker?
Did you want to admit the violation to go to Phoenix House?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights you're waiving?
Yes, sir.
Has anyone forced you or threatened you to enter this admission? Yes, sir. Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs did for you on your case? Yes, sir. Court finds the admission freely and voluntarily entered. Court accepts it, revokes and terminates probation, sets a new term of 2 years probation. Enter and complete Phoenix House, bars to bed, $100 cost prosecution, $150 PD fee, and complete original requirements of probation, and adjudicated guilty.
Thank you, Judge.
Okay.
Probation fees waived, Your Honor?
Yes.
All right. So you'll meet with probation, but you'll meet with them first. Your Honor, Tim Gibbs on behalf of Mr. Steve Clance. Judge, this is 24 CF 2514. This morning we were set for a bond hearing. He's currently charged by information with one count of possession of a short barrel rifle or shotgun. That charge itself has a $7,500 cash professional bond attached. The state did not go forward on the other 2 counts, so those 2 counts are now moot. However, they did direct file on possession of firearm by a convicted felon, so he's not actually being held on that charge at this time. Judge, we are requesting that his bond be reduced. Originally, when I wrote the motion, I was under the impression that it had 3 counts, so I'd asked for $2,000 on each count. We would ask, Judge, I would move to orally amend the bond motion to ask for a signature bond. We did get body cam this morning. The stop itself was predicated on a tag being bent to where it was not legible. Looking at the body cam, the tag is visible. It is bent a little bit, but it is visible. So there would be a potential motion to suppress there. The state had also previously offered, I believe, a downward departure of 3 years probation, then 2 years probation. Mr. Clance is self-employed as an owner of 3C Construction and Handyman Services, so his family's losing income. He's been widowed since 2021, would be residing locally, has lived here for 30 years, don't believe he has any failures to appear, so we would actually be asking for a signature bond so that he can bond himself out as well, since he's unable to afford his current bond.
State, sir.
Your Honor, I had agreed to the 6,000 cash professional, and I would make it 3,000 per count. He indicated in his motion that he could afford that, so I agreed to that. But also, I want to state that the offer that I made of probation is revoked at this time because he scores prison. So if he needs to file a motion to suppress, we'll deal with that.
He scores prison.
He scores prison, 27 months.
I'm gonna leave the bonds the way they are then. You may win your motion to suppress and you win, so, okay, thank you.
Not guilty plea.
Cooper.
Your Honor, Tim Gibbs on behalf of Mr. Randy Cooper. Judge, this is 24 CF 2513. We're here for we were here set for status as well on 24 CF 1832. Judge will enter not guilty pleas all around. I believe he's already set for December 30th.
He's charged with grand theft, right?
He's got a grand theft and then a new grand theft, Judge.
All right, okay, thank you, sir.
Your Honor, Tim Gibbs on behalf of Mr. Zachary Dalton. This is 072678. Judge will enter a denial on this case and set this for January 9th.
All right, January 9th, thank you, sir.
All right. Your Honor, Tim Gibbs on behalf of Miss Adrienne Foreman. Pronounce your first name exactly. Adrienne. Miss Adrienne Foreman, Judge. This is 24 CF 2592. Judge, we are here for a motion to reduce her bond. Judge, she's been arrested on several counts involving credit card fraud. However, we are still trying to get body cam and surveillance video of this so that we can confirm what her involvement may actually be. I don't believe it's as extensive as the arrest report indicates. Her total bond currently, Judge, is $74,000. She would request, Judge, that her bonds be reduced to $1,000 per count. We don't have an offer yet from the state as far as trying to resolve it, but she has lived in Florida for 32 years. She does reside in Gainesville. She actually owns her own food truck down in Gainesville. She does have 2 children, ages 12 and 14, for whom she cares, as well as her mother, who recently had a stroke, and her mother suffers from congestive heart failure. She has a 12th grade level of education. She's completed an HVAC certification as well, so she could be gainfully employed. I don't believe she ever has failed to appear in court, and I don't believe that she would be a flight risk, Judge. At her first appearance, she was listed as a violent felony offender of special concern because she also had a warrant for a violation of probation from the state of Illinois. However, according to the first appearance paperwork, that was according to the first appearance paperwork submitted by pretrial services. But it was noted at her first appearance that the other state, whether it was Illinois or Iowa, did not wish to extradite. So the court did not find probable cause at her first appearance for violation of probation. Since she doesn't have a violation of probation, otherwise she would not qualify as a violent felony offender of special concern. So Judge, we're asking to reduce her bonds to $1,000 cash professional on each count, pending, of course, discovery and surveillance video.
What's the state say?
I just want to mention that she does score prison time. In a prior record, she's got a robbery without a weapon and then forgery of written instrument. I don't think she lives locally.
She does not. She lives in Gainesville.
And that's going to be an issue for the state, Your Honor. She, as I said, she scores prison time. I would ask for a cash or professional bond.
I'm going to leave it the way it is. Thank you.
There was one other state's motion to revoke bond on the 9 o'clock docket that we did not hear, Judge Weaver. It was Elisa Rivers' case, but I believe she filed a motion to withdraw, or Weaver, number, I have it on page 22. State had filed a motion to revoke bond under 903, Florida statutes 903.0471, based on his arrest. While out on bond in this case, he was arrested in Walton County for trafficking in fentanyl. That arrest was on November 5th of 2024. He posted bond in this case before the court on August 29th of 2024. It's a probable cause finding, for Your Honor, under 903.0471, and I did attach that arrest report to the state's motion.
Where's he at?
He bonded out of Walton County after getting arrested on the trafficking in fentanyl as well, so I do not know where he is.
All right, I'll revoke his bond. If you send me an order.
Thank you, Judge.
Who else we got? Got the afternoon docket now?
We're on to arraignments.
We'll take about a 15-minute break.
All rise, please. Here again, Sundays, 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850
charges are against you, the right to an attorney, the right to a trial by jury, or you may get your case resolved right now. The state may make an offer to you that if you want to enter a plea today, that this is what your sentence would be, and I'll give you the sentence that they recommend unless there's something really unusual. So when I call your name, come up, you'll be told what your charges are, and you can, if the state gives you an offer, you can decide to take it or not, and if you don't want to and you'd like to have an attorney, I'll be happy to appoint an attorney to represent you, okay? All right, now, Mr. Williams, who did you want to talk to?
Judge, Holly Mason is one of my cases. She approached me as I re-entered the courtroom.
All right. Where is she?
If you stand up so the judge can see it. Judge, I'm going to go ahead and enter a plea of not guilty on her behalf, request 15 days pre-arraignment motions and trial by jury.
All right, which day in February is the
Set for December 30th right now.
December 30th? All right, I'll appoint the public defender if not already, and then December 30th, come back, okay, to court, okay? Before then, get with your public defender. Thank you.
Thank you, Judge.
Barbara Abrams.
Your Honor, Tim Gibbs on behalf of Ms. Barbara Abrams. Judge, we're here for arraignment in 24 CF 2516. Ms. Abrams will enter a not guilty plea, request 15 days for any pre-arraignment motions, demand trial by jury. I also see that she's got a new case, 24 CF 2753, that will enter a not guilty plea in as well, if that's acceptable. And we'll leave this set for pretrial, Judge.
All right, Ms. Abrams, you're charged with possession of a controlled substance without prescription, possession of narcotics equipment. You'll be brought back to court on December 30th.
Thank you, Judge.
Okay, thank you. Samuel Allen.
Your Honor, Tim Gibbs on behalf of Mr. Samuel Allen. Your Honor, this is 24 CF 2484. Judge will enter a not guilty plea, request 15 days for pre-arraignment motions, and demand trial by jury.
All right, Mr. Allen, you're charged with drug possession without a prescription, tampering with evidence, and possession of narcotics equipment. You set for what day? 30th?
Yes, sir.
If you wear shorts, don't wear shorts next time. I'll have to put you in jail. Thank you.
Is this Mr. Allen's only pending case? That, you know?
As far as I know, yes.
The offer on this case, I believe it's the only case, is a withholding credit for time served with court costs, if he's interested.
Judge, he would like to accept that offer today.
Mr. Allen, please raise your right hand to be sworn. You swear the testimony you give before this court is truth, so help you God.
Sir.
You want to enter a no contest plea to possession of controlled substance without a prescription, third-degree felony, obstruction of justice. Is that a third-degree felony also?
Should be a misdemeanor.
And misdemeanor.
So that's a resisting without.
Yes.
First-degree misdemeanor.
I've got obstructing justice, tampering with evidence.
It's, I believe I filed on the tampering with
Yeah,
evidence, third-degree felony.
All right, and possession of narcotics equipment, third-degree felony.
No, the possession of narcotics equipment is the misdemeanor.
So you want to enter a no contest plea to those charges? Has anyone forced you or threatened you to enter a plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
All right, court finds the plea is freely and voluntarily entered. Court accepts it. Is adjudicated guilty.
Withhold, Judge.
Withhold adjudication. Sentence you to credit for time served, standard court costs, give you 90 days to pay it or it goes to a judgment.
Yes, sir.
And don't wear shorts or you have to be put in jail.
Sure.
Okay?
Thank you, Judge.
Thank you. Daniel Earl Arn,
We handled Mr. Arney this morning, Your Honor.
Donnie Beck,
Your Honor, Tim Gibbs on behalf of Mr. Donnie Beck. Judge, this is 24 CF 2373. Judge will enter a not guilty plea, request 15 days for any pre-arraignment motions, demand trial by jury, and leave this set for pretrial.
All right, Mr. Beck, you're charged with vehicle theft and petty theft, so we'll see you December 30th.
Double jeopardy, I was charged already in Mississippi for it.
We'll talk more about that. We're still working on the rehab options as well.
What about passing speed trial on demand?
This is just your arraignment. If he wants to file a double jeopardy motion or something, he'll be happy to hear it. Okay? Thank you. Jake Bell,
We heard Mr. Bell this morning, Your Honor.
Anisha Berry, Ms. Berry, you're charged with battery on an officer or firefighter and resisting arrest without violence. Is there an offer
Not
for?
guilty on both charges, and I'm not accepting no pleas, and I will be getting an attorney. I'm claiming police brutality.
You're doing what?
Yep.
You want to
In
get?
my home,
You want to
beating
get
on
in?
my son, and that's how I got it, because they wouldn't listen to me. I asked them to please stop. They sacked them, all 4 officers, and I tapped them on the back, and then they said, cuff her, shoved me face first. After they beat me, we both got hospital reports for concussion.
All right, so you want to get your own attorney, you said?
I'm gonna get Gillis, yes.
Okay.
So I'm
And-
not guilty, and I'm not accepting no charges.
What's your court date? December 30th, thank you.
Okay, you're welcome.
See, that's how you do it. You just plead and just demand, you don't get your own attorney and you just, let's get right down to business. Israel Black. Everything you say could be used against you because it's recorded, so she was kind of talking too much and might be used against her, so. All right, Mr. Black, you charged with driving license suspended, second or subsequent offense. Is there an offer for him?
Judge, the state is going to be transferring this to misdemeanor. There's no basis to file as a felony.
All right, they're reducing the charge down to misdemeanor. Does he have a court date with that?
Not yet.
You'll get notice of when to be in court, but you're already doing a great job. Felony down to misdemeanor, okay? So you'll get your court date, okay?
Appreciate you.
Thank you. Joseph Carroll.
This is just your copy. Your Honor, Tim Gibbs on behalf of Mr. Joseph Carroll. Judge, this is 24 CF 2383. Your Honor, we'll enter a not guilty plea. Request 15 days for any pre-arraignment motions, demand trial by jury.
All right, Mr. Carroll charged with lewd and lascivious behavior. See you what day, 30th? Yes, sir. December 30th. Thank you. Arthur Cheever.
Your Honor, Tim Gibbs on behalf of Mr. Arthur Cheever. Judge, this is 24 CF 2392. This is your copy, Mr. Cheever. Your Honor, we'll enter a not guilty plea, request 15 days for pre-arraignment motions, demand trial by jury. Believe this is actually going to be transferred down to the south end. He's got another case down there.
All right. Has he got a court date?
On the 9th.
December 30th, and you'll get a, if it gets transferred down, you may have a different court date, okay?
Yes, sir.
Thank you.
Court date too, yes.
Steve Clance? or
We handled
Clancy?
Mr. Clance this morning, Your Honor.
Jonathan Collins.
Your Honor, Tim Gibbs on behalf of Mr. Jonathan Collins. He is present and approaching. Judge, this is 24 CF 2510. Judge will enter a not guilty plea, demand trial by jury, and request 15 days for any pre-arraignment
All right.
motions.
Mr. Collins, you're charged with fleeing a lewd police officer, possession of controlled substance without a prescription, possession of cocaine, and destroying evidence. December 30th, okay? Thank you. Valerie Davis. All right, Ms. Davis, you're charged with driving with a permanently revoked driver's license.
Plead not guilty today, and I'll have to set you for December 30th. Your Honor, we don't have an agreement at this time. We have been trying to negotiate already. Because of that, I'll have to enter a not guilty plea on her behalf, request 15 days of pre-arraignment motions, and demand trial by jury.
All right, December 30th.
Thank you, Judge.
Cheyenne Dowell.
Your Honor, Ms. Dowell is present and approaching. This is 24 CF 2538. Okay.
Charged with.
We'll enter a not guilty plea.
Okay, you're charged with battery on a 65-year-old person or older. See you December 30th.
Thank you, Judge.
Delroy Durham.
Your Honor, Tim Gibbs on behalf of Mr. Delroy Durham. Judge, this is 24 CF 2412. Your Honor, we'll enter a not guilty plea, request 15 days for pre-arraignment motions, and demand trial by jury.
Mr. Durham, you're charged with possession of meth and possession of controlled substance without a prescription. See you December 30th. Thank you. Charles Emerson.
Your Honor, Tim Gibbs on behalf of Mr. Charles Emerson. Judge, this is 24 CF 2509. Your Honor, we'll enter a not guilty plea. He has another case in the South End. This case will be transferred down with that case as well.
All right, charged with possession of personal ID of deceased person. You'll be transferred to the South End. Thank you. Elijah Falls.
Your Honor, I filed a written plea of not guilty on behalf of Mr. Falls.
December 30th.
Thank you.
Sebastian Fletcher.
Your Honor, the bailiff has brought out Mr. Nicholas Espinosa. He should be on the afternoon docket as well.
This is Espinosa?
Yes, Nicholas Espinosa. Okay. Charged with aggravated assault without intent to kill, 2 counts, and also battery.
Your Honor, Mr. Nicholas Espinosa does want to enter a plea of no contest to this charge, but he does want to enter it to the bench. He would qualify as a youthful offender. I'm not sure if the court would be willing to sentence him today. We would request that the court would be sentencing him today.
No.
Whatever the next available court date is then that we have.
December 30th.
Very well. For now, then, we'll enter a not guilty plea, Judge.
Sebastian Fletcher.
Your Honor, Tim Gibbs on behalf of Mr. Sebastian Jamarcus Fletcher Gillette. Your Honor, this is 24 CF 2477.
Charged with dealing in stolen property and false info to a pawn shop. We'll see you December 30th. Thank you.
Thank you, Judge. Yeah, give me a call.
Holly Godwin.
Your Honor, Tim Gibbs on behalf of Ms. Holly Godwin. Judge, this is 24 CF 2400. Will enter a not guilty plea, request 15 days for pre-arraignment motions, demand trial by jury.
Godwin charged with destroying evidence, driving license suspended, and possession of narcotics equipment. December 30th.
Give me a call, make an appointment.
Stephen John Harrell. Mr. Harrell, you're charged with possession of a weapon by a convicted felon and possession of a controlled substance without prescription. I've got Mr. Williams as his attorney.
I'm sorry, Judge, what's the name?
Stephen Harrell.
Yes, sir, he is. Mr. Harold, this is a copy of the charge against you. Judge, I'm going to enter a plea of not guilty on his behalf, setting or request 15 days for pre-arraignment motions and setting for trial by jury.
December 30th.
Keep you moving down the...
Robert Harrison.
Yeah, you do. You need to make an appointment and come in and see me.
Not done right now.
Sir, yeah, you're done. Yes, sir. Mr. Harrison? Yeah, come on up, Mr. Harrison. Judge, same thing with Mr. Harrison. Harrison, this is your copy.
You're charged with aggravated battery, Mr. Harrison, December 30th.
Thank you.
Zier Jean-Louis.
Judge, we have a negotiated plea in Mr. Jean-Louis's case.
All right. Mr. Jean-Louis, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God. Okay.
Mr. Jean-Louis, this is your copy of the charging document, okay?
All right, you want to enter a no contest plea to the charge of fraudulent use of a credit card, a third-degree felony, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Did you read and sign this form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
All right, did anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Okay. Court finds the plea is freely and voluntarily entered. Court accepts it. Sentences you to judge guilty, 3 years probation. Reserve 90 days for restitution, no trespass at Rent-A-Center, standard court costs, cost of prosecution, and PD fees. And you wrote concurrent, but I only see one count.
Judge, I don't know why I did that.
All right, your case is concurrent with no other cases.
I'm not aware, you don't have any other cases pending, do you? Oh, that's right, you've got the case over in Walton. Judge, he's got a sentence he's currently serving over in Walton. I'd rather him do both
All right,
probations at one
concurrent
time.
with Walton County.
Yes, sir.
Your Honor, he's already on supervision over there for some of their stuff.
Okay, well, it's concurrent with Walton County case, okay? Is he going to be supervised over there on this case?
Yes, sir. Tomorrow I got to go to Okaloosa Courthouse for it. They moved it to Alabama.
Well, talk to probation. I don't want you to get in trouble, okay? Because that don't sound right.
Yes, sir.
To me. But I'm putting you on 3 years probation concurrent with Walton County cases. That's not Andalusia. I don't know why they'd have it.
Because I live in Alabama, so they transfer it.
Oh,
Yeah.
okay. Well, check with probation anyway. Make sure you don't get into trouble.
Yes, sir.
Okay.
Based on those circumstances, I don't know how this works, but if he has to pay another $100 transfer fee, just so the court understands.
You may have to do that.
Shouldn't have to, but.
I'll say waive it if that helps him.
Okay. thanks.
Okay.
And we'll request the supervision fees be waived.
Yeah.
Thank you.
All right. David Johnson.
Judge, I believe Mr. Johnson we handled this morning.
William Cohen.
Judge, Mr. Cohen's charged with possession of methamphetamine and felony driving while license suspended. No, excuse me.
I have a driver's license suspended or revoked with prior conviction.
I think what I'm looking at is a scrivener's error on the information up top. Or maybe it's, no.
It's the third or subsequent driving on a suspended license. First degree misdemeanor, but it does carry a mandatory 10 days jail.
Okay.
All right, possession, one is possession of controlled substance without a prescription. So, December 30th, okay?
Thank you, Judge.
Thank you.
All right, make an appointment, come in and see me and talk about this, okay?
Amanda Lawson.
We took care of her.
Judge, we did that this morning.
James LeBaron or LeBron? Or is it LeBron James? Which James LeBron or LeBron James? Which?
It's James LeBron, Judge. Come over here, Mr. LeBron. There you go. Judge, this is a negotiated plea.
Okay.
I think the state's signing that. Okay, thank you. It's a felony criminal mischief, Judge, third-degree felony.
Mr. LeBron, would you please raise your right hand to be sworn? You swear the testimony you give for this course is the truth, so help you God. You want to enter a no contest plea to the charge of criminal mischief, a third-degree felony, correct? Did you read and sign this agreement, which, and the rights you're waiving, you understand that?
Yes, sir. Yes, sir.
Has anyone forced you or threatened you to enter this plea? You're pleading no contest to criminal mischief, you understand that? All right. Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it. Sentence you to a judge guilty, 3 years probation, $3,500 restitution, take an anger management course, no trespass at Panera.
Panera Bread Restaurant, Judge.
Okay. Is that any Panera or just Panera and where?
We'd ask for it to be this Panera because there's significant restitution owed.
What Panera is that? Is there one in Crestview?
There is.
There is?
There is, Judge.
Is it the Crestview Panera?
Down towards the interstate.
There's probably some other restaurants around there that you could eat at, so, $515 court cost, $100 cost of prosecution, $150 PD fees. Adjudicated guilty. Thank you.
Thank you, sir.
Did you order the restitution?
Yeah, $3,500 restitution.
Yes, sir. Thank you.
And we request the supervision fees be waived.
Yeah.
And that $3,500 $3,500, I assume it's the Panera Bread.
Yes.
Yep. Right.
All right, sir. They're going to need to talk with you right over here, right behind you.
Jessica Livingston.
Hey, Ms. Livingston, that's your copy of the charge, okay? Ma'am, do you understand that regardless of whether you go to Bridgeway or whether you go to ECLC, you still have the random urinalysis
Yes.
to make sure you're not using it?
Yes.
Okay.
All right, Ms. Livingston, would you raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
Okay. You want to enter a no contest plea to charge of criminal mischief, 3 counts, 3 third-degree felonies, and possession of paraphernalia, first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On a misdemeanor, you're judged guilty, sentenced to time served. On all felony counts, you're judged guilty, sentenced to 5 years probation, concurrent restitution total of $5,700 at a rate of $100 per month, $515 court costs, $100 cost of prosecution, $150 PD fee, have a substance abuse evaluation and treatment, or ECLC. Compliance, no trespass at Cash America Pawn, 299 South Main Street, Sophie's Nails, 217 South Main Street, and AC by DC, yeah, $301, excuse me, 301 South Main Street, all in Crestview, and random UAs. And I guess that restitution is divided up somehow with those businesses?
I've got it at $100 per month, and then
I could give you the breakdowns if that's required. So $3,500 is owed to Cash America Pawn, $1,200 is owed to Sophie's Nails, and $1,000 is owed to AC by DC.
All right, that's what the court orders.
$1,000 to AC by DC, the business. The $100 a month is minimum restitution payments.
Yeah, minimum restitution payment, $100 a month.
they're going to instruct you on that. And as long as it's in Florida, they'll find one that's close to where you live.
Okay.
Okay?
Larry Mayo.
You're going to go ahead and have a seat over there so that they can talk with you.
And we got Larry Mayo here today. He's not got an attorney.
Yeah, I think Mr. Mayo is unrepresented.
He received notice here. He's got a warrant. No bond, Capias. Jason McDonald.
I think we handled it this morning, right, Mr. Williams? Yeah.
Wesley Moore.
Judge, Mr. Moore showed up this morning by mistake. We handled him.
All right. Zachary Neal.
I still have Mr. Nell. Mr. Nell, that's a copy of the formal charges against you. You're going to need to set an appointment to come see me, okay?
Charged with possession of controlled substance and no motorcycle endorsement. What does that mean?
Yes, sir. Mr. Nell and I still need to talk, so I'm going to just enter a plea of not guilty on his behalf today. Let me look and see if there's anything.
All right, December 30th.
Just so that you know, they're looking for 3 years probation. Okay?
Tyler Nichols. James Phelan.
That's mine.
Phelan?
All right.
Your Honor, this is Mr. Phelan. He's before the court on 24 CF 2472. We're going to enter a not guilty plea and request trial by jury.
All right, charged with 3 counts of intimidation by writing and 3 counts of two-way communication device to facilitate a felony. December 30th, thank you. Sylvia Finney. She's charged with drug possession without prescription and possession of narcotics equipment.
The state made an offer if you're in. Your Honor, she's charged with possession of controlled substance, possession of drug equipment. She is going to tender a not guilty plea at this time and request trial by jury.
And December 30th, thank you.
You okay?
Shane Reed.
Your Honor, he's in custody.
Reed?
Mm-hmm. You're right.
You're charged with battery on a person in a detention facility. Charged with battery on a person in a detention facility.
This is my case, Judge. My offer was 6 months jail. He's asking if he could do probation.
I haven't been in trouble since 2019. I mean, I was only here for this jail to get transferred to Walton County for something that I didn't even do, and it's 5 years old, a warrant from 5 years ago.
So you'll be able to do probation here in Florida?
Oh, yeah. I haven't been in no trouble.
We can give it a shot. Thank you. You do.
Like, I was working. I was doing really good, actually.
How many years probation or what?
Let me look at the score sheet, Judge. It would be 3 years probation. We could look at early termination after 2 years if he's no contact with the victim.
Yeah, I'll do that. Yeah, I haven't been in no trouble. Like, I've been working and actually doing good. Like, when they picked me up, I was just walking down the street, and I had
How long you been in jail?
60 days.
60.
The state would ask for a, actually, I think a mental health eval might be appropriate as a term of the probation. The court cost is $967, and there's no violent contact, or really just no contact with the victim.
Never met him.
All right, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God? You want to enter a no contest plea to battery on a detained person in a jail facility? I guess that's a third-degree felony, isn't it?
Yes, Your Honor.
And you want to enter a no contest plea to that? Are you aware of the rights you're waiving by entering that plea? Anyone force you or threaten you to enter that plea? Are you under the influence of medication or drugs that prevent you from knowing what you're doing? Are you happy with the work Ms. Rivers did for you on your case? The court finds the plea is freely and voluntarily entered. The court accepts it, adjudicates you guilty, sentences you to 3 years probation. You can have early termination at 2 if you stay out of trouble and complete the terms of probation. Standard court costs and cost of prosecution.
And Your Honor, would the court be willing to waive monthly
Yeah, waive
supervision fees?
waive cost of supervision. Okay?
Judge, I just have to make one correction to the score sheet.
All right, so don't mess up, okay?
I won't. I appreciate it.
Score 25.
Okay.
That's what I had was 25 points.
Yeah.
All right, thank you.
You're going to have to meet with him.
Jamie Rose.
Your Honor, we've reached an agreement in that case. I just need to get a copy of the plea agreement.
All right. Ms. Rose, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
I do.
You want to enter a no contest plea to the charge of illegal use of personal information, a third-degree felony?
I do.
And you read and sign this plea and sentencing agreement, which discusses the rights you're waiving?
I do.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge is guilty. Sentenced to 60 days Okaloosa County Jail, $13 restitution to Allie Mays. $415 court cost, $100 cost of prosecution, $100 PD fee, and $50 app fee. Okay?
Thank you, sir.
Thank you. Savannah Scott.
Your Honor, Ms. Scott is present and approaching 24 CF 2254. She's charged one count of child neglect. And speaking with her, we're going to enter a not guilty plea and request trial by jury.
All right, December 30th. You're charged with child neglect without great harm. Thank you. Thomas Selman.
Your Honor, we've reached an agreement in this matter. Oh, did I not mark it? Yeah.
All right.
Your Honor, I did read over the document, that the parts that applied to Mr. Selman.
Mr. Selman, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes.
Do you want to enter a no contest plea to the charge of possession of controlled substance, a third-degree felony, and possession of drug equipment, a first-degree misdemeanor?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you, threaten you to enter this plea?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case? You are?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it on both counts. Sends you to credit for time served. Judge guilty. $515 court costs, $100 cost of prosecution, $100 PD fee, $50 app fee. Okay?
If you take this with you when you go to the clerk's office, they can pull up the information so you can make your payment plan.
Okay, thank you.
Kenneth Singletary.
He's in custody, Your Honor.
Singletary.
Honor, my client made a counteroffer. I just need to convey to him the state's response. Yeah.
Run concurrent with my
CDR? CDR, yeah, they don't have any control over that part.
no probation.
Yeah, no probation. You gotta sign it right there. We've reached an agreement in this matter, Your Honor. It's gonna be 11/29 in the Okaloosa County Jail. He does want to take part in the ECLC program there at the jail. So I did put that down there.
All right, Mr. Singletary, would you please raise your, Mr. Singletary, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir.
Okay. You want to enter a no contest plea to charge of felony battery, a third-degree felony, correct?
Yeah, listen to him right now.
You want to enter a no contest plea to this charge of felony battery, third-degree felony?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing? Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you 11 months, 29 days, Okaloosa County Jail. Standard court costs, and the court will recommend or allow you to do ECLC in jail.
And Your Honor, he is going to have a CDR time. He asked if the court had any objection to it running concurrent.
No, I'll say concurrent.
See? There you go. Good luck, Mr. Singletary. Okay. Your Honor, we did Mr. Smiley this morning.
All right. Scott Michael Smith. No bond, capious. Sonia Snowden.
Your Honor, Ms. Snowden is present and approaching. We've reached an agreement in this matter.
All right, Ms. Snowden, would you please raise your right hand to be sworn? Other right hand.
Oh, my bad. I'm sorry.
Swear the testimony you give for this court is true, so help you God.
Yes, sir.
Your Honor, I did add on here, or ECLC.
You want to enter a no contest plea to possession of a controlled substance, you want to enter a no contest plea to a lesser offense of possession of marijuana under 20 grams, a misdemeanor, correct?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. 1 year probation, have a substance abuse evaluation or ECLC, complete any recommended counseling. You're not to possess or consume any alcohol or drugs without prescription. $270 court cost, $50 cost of prosecution, $50 PD fee, $50 app fee, waive cost of supervision. Adjudication withheld. Okay? Robert Sprague.
He's in custody, Your Honor.
Sprague.
Your Honor, I have an agreement for Mr. Sprague to sign, if I could just have a moment.
All right.
indicated to me that he was finally served last night with his violation of probation. And so the state had indicated that they were willing to do the same sentence for the violation of probation.
That is accurate, Your Honor. We had already discussed that. We had intended on addressing it in the future if it came up, but since it's already been served, we're amenable to doing it right now if the court is.
All right.
I just don't have the case number right offhand. Do you have it?
Like case number is 231089CF.
BOP and your new home. Control, ankle monitor, $1 per day, court costs, once they get you hooked up with the ankle monitor. All right, you want to do it, then you need to sign it right there. Uh-huh.
Mr. Sprague, would you please raise your right hand to be sworn? You swear the testimony you give for us court's true, so help you God?
Yes, Your Honor.
Okay. You want to admit that you violated probation and also plead no contest to failure to notify change in, registration conditions?
Vehicle ownership, Your Honor. I think it's how they listed it on the docket.
A third-degree felony?
Yes, Your Honor.
Mr. Sprague, is that what you want to do?
Yes.
Did you read and sign this sentencing agreement which explains your rights you're waiving?
Yes, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Anyone force you or threaten you to enter this plea in admission of violation of probation?
No.
Are you happy with the work Ms. Rivers did on your case for you?
Yes.
Court finds the admission and the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, sentence you 6 months community control. Have an ankle monitor at $1 per day, $4.15 court costs, $100 cost of prosecution, $100 PD fee, $50 app fee, waive cost of supervision, maintain employment. That was all on the felony. On the VOP, we will judge guilty. And what about concurrent community control?
That is our intention, Your Honor.
Concurrent 6 months community control and waive cost supervision.
$100 court costs.
$100 court costs. Okay? Thank you.
Are we revoking the old probation?
Yeah, we'll revoke the old probation, give him a new term of 6 months. Revoke the old, give him a new term of 6 months. Yeah, concurrent.
You just need to see them.
And he's to remain in custody until the GPS is attached.
Yes. Xavier Stakowicz.
Your Honor, my understanding is that they did not bring him over. I'm gonna enter a not guilty plea on his behalf, request trial by jury.
December 30th. Angela Sword.
All right, Your Honor, we're going to enter a not guilty plea. She is charged with possession of controlled substance, possession of drug paraphernalia, 24 CF 2494, not guilty, and request trial by jury.
All right, December 30th. Thank you.
Here.
Joseph Thompson.
Your Honor, he's before the court on 24 CF 2424. He's charged with 30 counts. We are going to enter a not guilty plea, request trial by jury.
All right, Mr. Thompson, charged with 30 counts of possession of obscene material. December 30th. Thank you.
Back out to see you.
Ralph Thompson.
To the right, sir.
All right.
Oh, I don't have a Ralph Thompson in my pile.
He's charged with retail theft of,
Jennifer's case, Miss Flowers' case, I think. Ralph Thompson.
I'll enter a not guilty plea on his behalf.
all right, December 30th. Okay, thank you. Your attorney's not here. She had an emergency or something. She had to leave, so the court's entering a not guilty plea for you. See you December 30th, and she'll be out to see you. Brittany Toller.
Your Honor, Ms. Toller is present and approaching. We've reached an agreement in this matter, if I may approach.
All right, Ms. Toller, please raise your right hand and be sworn. You swear the testimony you give for this court is true, so help you God.
Yes.
You want to enter a no contest plea to grand theft auto, a third-degree felony, and resisting arrest without violence, a misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you, threaten you to enter this plea?
No, sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count one, you're judged guilty, 3 years probation. May early terminate after 2 years if all terms and conditions are complete. Waive cost supervision. No contact with Christine Campbell. Maintain gainful employment or 5 applications per week.
To a judge.
2,
Yes, sir.
She has a job.
okay, or 2 applications per week. 515 court costs, $100 cost prosecution, $100 PD fee, $50 app fee. On count 2, resisting arrest without violence, you're sentenced to 1 year probation concurrent.
And Your Honor, I may have written
Withheld
it down wrong. It's adjudication withheld on the felony.
on both of them?
Yes, Your Honor.
Okay, adjudication withheld on both counts.
Your Honor, is that no contact or no violent contact?
Who is that? Is that a law enforcement officer, Christine Campbell?
The lady's car that she had used.
Oh. We'll say, is
The
she?
state would
a-
ask for no contact, and if the victim wants to change it, she can change it with probation.
All right, no contact.
Thank you.
She's fine with that, Your Honor.
Okay. Thank you. Veronica Velasquez. No bond, capious. Dallas Walder. Dallas Walder. No bond, capious. I think that's all who is this?
I believe Mr. Mayo.
What's your name, ma'am? Oh, Dallas Walder? Okay.
Your Honor, we're going to enter a not guilty plea, request trial by jury. Give me an opportunity to meet with Ms. Walder.
All right, I'll withdraw that capious on Ms. Walder. You're charged with possession of controlled substance without prescription, another count of possession of controlled substance, and possession of narcotics equipment. See you December 30th. I'll withdraw the capious, okay?
Okay,
Thank you.
Oh, thank you.
Was there someone else?
I believe Mr. Mayo.
Mayo? Come on up, Mr. Mayo. Did I issue a capious for Mr. Mayo?
I believe you did, Judge. Judge, but he's unrepresented at this point.
All right, I'll withdraw the capias. All right, Mr. Mayo, you're charged with possession of controlled substance, possession of less than 20 grams of marijuana, a financial responsibility violation, and driver license with driving with license suspended or revoked with a prior conviction. Do you want an attorney to represent you?
Yes, sir.
Okay, I'll appoint the public defender.
Judge, I'll enter a not guilty plea on his behalf, 15 days pre-arraignment motions and trial by jury.
December 30th. Is anyone else here for a plea day arraignment?
If you're talking about the one from earlier today, did you withdraw?
No, sir, this is a misdemeanor FTA.
Oh,
I was
okay.
already aware of it.
Okay.
Anyone else here for arraignments? All right, we'll take about a 15-minute break.
All rise.
Anna, we just have some sentencing.